I get my peaches out in Georgia, ooh that's it. I get my weed from California, yeah that's it. I took my girl up to the north, yeah, real bad chick. I get my light right from the source, yeah, yeah that's it. I get my peaches out in Georgia, ooh that's it. I get my weed from California, yeah that's it. I took my girl up to the north, yeah, real bad chick. I get my light right from the source, yeah, yeah that's it. And I see the way I breathe you in, it's the texture of your skin. I wanna wrap my arms around you, baby, never let you go. And I see there's nothing like your touch. It's the way you lift me up, ooh yeah. And I'll be right here with you till the end. I get my peaches out in Georgia, ooh that's it. I get my weed from California, yeah that's it. I took my girl up to the north, yeah, real bad chick. I get my light right from the source, yeah, yeah that's it. I get my peaches out in Georgia, ooh that's it. I get my weed from California, yeah that's it. I took my girl up to the north, yeah, real bad chick. I get my light right from the source, yeah, yeah that's it. I get this feeling so I'm sure, and in my hand because I'm yours. I can't pretend I can't ignore you, right from me. I don't think you wanna know just where I've been, oh. Don't be distracted, the one I need is right in my arms. Your kisses taste as sweet as with mine. You know me well, yeah, with you till the end. I get my peaches out in Georgia, ooh that's it. I get my weed from California, yeah that's it. I took my girl up to the north, yeah, real bad chick. I get my light right from the source, yeah, yeah that's it. I get my peaches out in Georgia, ooh that's it. I get my weed from California, yeah that's it. I took my girl up to the north, yeah, real bad chick. I get my light right from the source, yeah, yeah that's it. And I see the way I breathe you in, it's the texture of your skin. I wanna wrap my arms around you, baby, never let you go. Oh. And I see there's nothing like your touch. It's the way you lift me up, ooh yeah. And I'll be right here with you till the end. I get my peaches out in Georgia, ooh that's it. I get my weed from California, yeah that's it. I took my girl up to the north, yeah, real bad chick. I get my light right from the source, yeah, yeah that's it. I get my peaches out in Georgia, ooh that's it. I get my weed from California, yeah that's it. I took my girl up to the north, yeah, real bad chick. I get my light right from the source, yeah, yeah that's it.
You're on the couch, blowing on my phone. You don't wanna come out, but you don't wanna be alone. It don't take but two to have a little soiree. If you're in the mood, sit tight right where you are, babe, 'cause I'll be at your door in 10 minutes. Whatever you got on, girl, stay in it. You ain't gotta leave the house to have a good time. I'ma bring a good time home to you. We'll have a house party, we don't need nobody. Turn that TV off, break that boombox out. We'll wake up all the neighbors till the whole block hates us, and the cops show up, try to shut us down. If you're gonna be a homebody, we're gonna have a house party. If you wanna be a homebody, we're gonna have a house party. Gonna be a homebody, we're gonna have a house party. If you wanna be a homebody, we're gonna have a house party. Throw neon t-shirts over the lampshade. I'll take the furniture, slide it out of the way, shaking the floor, rattling the roof. We'll go to town like they're in your living room. Let's have a house party, we don't need nobody. Turn that TV off, break that boombox out. We'll wake up all the neighbors till the whole block hates us, and the cops show up, try to shut us down. If you're gonna be a homebody, we're gonna have a house party. If you wanna be a homebody, we're gonna have a house party. Gonna be a homebody, we're gonna have a house party. If you wanna be a homebody, we're gonna have a house party. 'Cause I'll be at your door in 10 minutes. Whatever you got on, baby, stay in it. You ain't gotta leave the house to have a good time. I'ma bring a good time home to you.
New York, LA, Berlin, say hey to Tokyo, Rio, De Janeiro. Here we go. Hello, hello, can you just feel it? Are you ready to go? Hello, hello, do you receive my echo? My life is a party, my home is the club. I party like a rock star, dance until I drop. My life is a party, my home is the club. My stage is the dance floor, party never stops.
did say hey. It's a good song. Alright, let's do it. How you doing? My name's Grant Smith-Ellis. We got a motion to read. I got a lot of things going on. If I didn't read this ruling, it's not a motion, it's a ruling. If I didn't read it right now, I already read through some of it, and then I was like, oh god, Judge Gilday is talking about the burden shifting analysis. I'm going to have to read this to them. So then I was like, oh yeah. And then I decided if we're going to do this, we got to do this now, because the stock market's going to close in like 2.5 hours. And you know what that means. All hell is going to break loose. You know, that's how things go these days. So anyway, my name's Grant Smith-Ellis. Welcome to Towel News. How are you all doing? Nightbot, be nice. We have some friends. Nightbot, you be nice to our new friends. What do you? Nightbot's very overly sensitive. Anyway, God bless you all. Thank you for joining Towel News. My name's Grant Smith-Ellis. If you've never hung out with Nightbot before, listen. You either love or hate Nightbot, alright? You're going to either come to love or hate him. The water under the fridge tries to start a revolution against Nightbot every single night. It's great. Nightbot's great, though. Alright, my name's Grant Smith-Ellis. We got a ruling to read from Judge Gilday. It's not good. It's bad. Alright? It can be appealed. Okay, but it's bad. It's very bad. On a scale, it's actually one of the only type of pre-trial rulings in a civil case that can be appealed. So I expect it will be appealed. But we got to read the ruling. Now listen, one of the sections of this ruling is going to make a lot of you like run around in circles and lose your mind. All right, it's an absolutely ludicrous analysis, and I only got through the part about TurtleBoy. Then I already was like, that's it. That's it. I was watching again. I kid you not. Towel Girlfriend will attest to this. I was watching the Ken Burns documentary about the American Revolution with Towel Girlfriend, as one is wont to do on a Friday. And I was just kind of, was like, oh, there's a ruling that came down, Towel Girlfriend. I start reading it. I got just through the section about TurtleBoy. I got so mad. I was like, that's it. I'm going live. I'm mad. Anyway, hashtag shout out Nightbot. Good to see you all. Welcome to the channel. Let me just put a few things in the chat, the Discord, the rules. Towel Girlfriend is wonderful. I agree. And let me just pin this thing. So I do this is a one-man show. So let me pin that. And then let me do a poll. Do you expect Karen Reed and Aidan TurtleBoy Kearney to appeal Judge Gilday's ruling? Yes? No. I demand goats. A lot of people are here just for the goats. I don't know if there's going to be a lot of goats during the stream. Some people, I feel like, actually watch this channel just because they like goats, which is fine. It's not really a goat-based channel, but more power to you. Watch, somebody inevitably is going to vote on that poll that they just want to see fiction videos of goats. I mean, they'll watch whatever. They don't really care what we're covering. The war, court cases, motions, rulings. They're waiting for the 30 seconds during the stream where I either talk about goats or play videos of goats. It's hilarious. Anyway, this is a debate. Alright, maybe all mad. Alright, so yeah, not only is it a bad ruling, it made me mad, and I only got through one paragraph. So let's go. I brought British Reporter Towel out for this for a few reasons. One, I had a surgery on my tooth today, so I'm not trying to talk a lot, while the tooth is healing. Second of all, I will analyze the motion, but I don't need to read 16 pages of Judge Gilday waffling, so we're just going to have British Reporter Towel do it. If you've never met British Reporter Towel, he's great. Oh, God, hold on. Pause, British Reporter Towel. Mary Cronin, that was so nice of you. Hold on. If your name is the Race of Air or Punxsutawney Phil of Dedham, I love that username, or Dizzy DD, welcome, or Mrs. Chop, I love that username, or Colleen, thank you so much to Mary Cronin 1188 for your wonderful support of Towel Channel. God bless you, and thank you for gifting the wonderful gift of towel emojis to all the wonderful people in chat who just unlocked their penguin-based emojis. Chat Mom Lynn loves penguins. We also have Chat Mom Bunny's dog. His name's Kofi. He's an emoji. We also have a channel mascot. His name's Pete Bunny Towel. He has an emoji. We also have Chloe the dog in a wig. She's in the undercover doggy informant program. Try not to talk too much about it. And of course, we have sheep. We have goats. We have all sorts of emojis. I mean, there's just all sorts of, animal-based emojis. David Yanetti's an emoji. Hey, do you know any other channels out there where David Yanetti is quite literally an emoji? I made an homage to David Yanetti that was like an homage to the man on the mountain in New Hampshire. And let's just say, ladies and gentlemen, he became an emoji. Clerk Margaret, the former clerk from Norfolk Superior Court, she's an emoji with Judge Doolin. Don't ask too many questions. I'm going to make her the Secretary of Commerce. And thank you very much for your towel membership. Enjoy. So yeah. It's probably the most unique emojis. Oh, also I can give out free memberships now. I can allow you to try it for free. I don't really know how it works. We're going to work on that. Anyway, God bless you all. Thank you for being here. My name is Grants with Elvis. Let us begin. I had to just pause there for that gift membership readout. Some people do it at the end. I like to read super chats and gift memberships as they come in. So it's just how we do it here. Take it away, British Reporter Towel.
Commonwealth of Massachusetts.
This is my towel cigar.
Plymouth, SS. Superior Court. Civil action. No. 2600541. Jennifer McCabe and others. Versus. Karen Reed and another. Memorandum of Decision and Order. On defendants, special motions to dismiss. Pursuant to the anti-SLAPP law, GL Cent. 231, Section 59H. Plaintiffs Jennifer McCabe, Brian Albert, Colin Albert, and Brian Higgins brought this action against defendants Karen Reed and Aidan Kearney, alleging they conspired to defame them by falsely stating they were responsible for the death of Reed's boyfriend, John O'Keefe. The first amended complaint, FAC, asserts claims against both defendants for defamation, intentional and negligent infliction of emotional distress, and civil conspiracy. The plaintiffs also assert separate claims against Reed for aiding and abetting in Kearney's defamation and infliction of emotional distress, and against Kearney for violation of GL Circa 934A. The defendants have each filed a special motion to dismiss the fact pursuant to the anti-SLAPP statute, GL Circa 231, Section 59H. For the following reasons, the motions are denied. Discussion. The anti-SLAPP statute, GL Circa 231, Section 59H, establishes a procedure for obtaining the early dismissal of a claim that seeks to impose liability on individuals for exercising their constitutional right of petition. Bristol as Fate, Company. Versus Rochester Bituminous Prads, Inc., 493. Brian Albert, Colin Albert, and Brian Higgins. Aidan Kearney. Greater than the defendants have also each filed motions to dismiss pursuant to Mass. RCIV. P. 12, B. 6. Those motions will be addressed in a separate decision.
Wait! Pause. Everybody hold on. Everybody hold on. Listen, why is it always in the footnote? Why is it always in the damn footnote? I can't be expected to read all the footnotes. Oh, God, help us. Pause. Everybody pause. Everybody pause. What are you doing to us, Judge Gilday? You're trying to drive Little Towel insane. Oh, my dear God. Everybody pause. They didn't lose their full motion. Everybody stop. Everybody stop. Stop. Everybody stop. Everybody got this wrong. Stop it. Time out. Justin. Oh, Jesus Christ. Oh, God, help us all. Karen Reed and Aidan TurtleBoy Kearney did not lose their entire motion to dismiss. Judge Gilday has only ruled on the anti-SLAPP portions of the motion to dismiss. The 12B6, which is a completely different motion to dismiss, that although they were conjoined, a 12B6 is a motion to dismiss under the precedents from Twombly and Iqbal, which is failure to state a claim. So only half of the motion to dismiss was decided. motions to dismiss remain outstanding. You read your footnotes, people. You gotta read the damn footnote. Oh, Judge Gilday. Oh, ladies and gentlemen, people were jumping on. Now, it looks like the motion to dismiss is denied in full, if you're wondering what's going on. It's not. Only half of Karen and Aidan's motions were denied. Only half of them. It's a two-part motion. I'm going to explain to you both of them. They both have different consequences, and they're both different types of motion to dismiss. Now, you might be saying, what does this mean? A motion to dismiss is a motion to dismiss, Grant. No, it's not. And we're talking about the civil context here, remember, not the criminal context. So we got to think about that as well. But I got to wait for this damn thing to load so I can post it. Would you mind? Would you mind? You making me all made? I'm trying to post a nice screenshot that I just made for the nice people. Why won't you load? Why are you making me all made? There it is. That took a while to load. Making me all made. So they did not lose the full motion. Before everybody gets in a giant like revolution, they did not lose the full motion. They only lost the anti-slap motion to dismiss. In a civil case, an anti-slap motion to dismiss is a special 59H, MGL 59H, motion to dismiss under what's called the anti-slap statute, the anti-strategic lawsuit against public participation. I'm not a lawyer, this is not legal advice, but I did graduate law school. Hashtag towel, JD. What are you going to do about it? So anyway, my point is, under 59H, an anti-slap motion to dismiss is what's called a special motion to dismiss. You got to meet a very high threshold, and you're basically saying, Your Honor, dismiss this lawsuit because every single claim that is brought against me is either the result of or derivative of my petitioning activity to the government or a body with the capacity to influence governmental decision making, and therefore I am insulated from civil liability because if you allowed me to be sued for this, in turn you would be chilling public speech on the whole. Everyone understand? Ironically, it's the same thing that the plaintiffs in this case, the H.A.M. plaintiffs, argued in federal court in front of Judge Caspa just like 2 weeks ago. They argued the same exact thing, but asking federal court to enforce state anti-slap law. There's no federal anti-slap law. There's just a bunch of state anti-slap laws, and they all function differently. But federal courts can enforce state law sometimes, and state courts can enforce federal law, obviously. It's complicated. It's called conflict of laws. It's a very interesting discipline. It's not what you think. It's not that the laws conflict. It's just like how courts of law and equity differentiate how they enforce their powers on the federal and state level and then across jurisdictions in that context. It's a little bit complicated. It's fun. I took the class. I did really well. Anyway, my point is, so this is an anti-slap motion to dismiss in front of Judge Gilday on the state level, all right? But simultaneously, so that's one of the motions to dismiss. In a civil case, you can also do something else, which is called a 12B6 motion to dismiss. In a 12B6 motion to dismiss, you are not arguing about whether your speech is petitioning activity. You're arguing that the plaintiffs have failed to state a claim upon which relief can be granted. Now, what does that mean? Well, you got to look at Twombly and Iqbal, my two favorite cases. So, Twombly is about the breakup of the Baby Bells in the 90s, and what happened basically was the Sherman Antitrust Act, another one of my favorite statutes, the Sherman Antitrust Act of 1891. You don't understand. I love it so much. I love the Robinson-Packman Act of 1934. I just love antitrust law. That's why the DOJ wanted me to be in the antitrust section. No one's heart sings out because of antitrust law, and no one has a very fond affinity for the Sherman Antitrust Act of 1891, but you're damn right that I do. I love all three sections of it. So anyway, the operative for our purposes, Twombly is a case about the Baby Bells, which was when AT&T got broken up. And the question was, when you're engaging the private right of action under Section 3 of the Sherman Antitrust Act of 1891, do you have to allege a plausible allegation sufficient to meet a standard under Rule 12b-6 of the Federal Rules of Civil Procedure and their state equivalents, and in turn, like preliminarily, as you're alleging this claim for antitrust violations and triple damages under the private right of action, do you have to meet the plausibility standard, which is higher than 12b-6. Prior to Twombly, like the general explanation is you walked into court with a piece of paper with some writing on it, and that was enough to survive a 12b-6. After Twombly, now here's why you got to really understand this. Twombly originally was just about the antitrust law. It was a narrowly applied holding of the Supreme Court of the United States of America. Okay? Now, Twombly gets interpreted outside of just antitrust claims in a case called Iqbal, which is even more interesting because Iqbal was suing like Rumsfeld or one of the Department of Defense like secretaries or something, Department of War, who the hell knows what it's called now. The point is the same. He's trying to sue him, and he is alleging like violations of his like civil rights, or trying to make a habeas petition under the 14th Amendment or some ridiculous thing related to Guantanamo Bay. Now, under Twombly and Iqbal, you got to understand, the court in the 1990s, that Supreme Court didn't really, under Rehnquist, didn't really love antitrust law, okay? They had some moderates there who were like checking and balancing, but they didn't love antitrust law. So they initially wanted to raise the 12b-6 plausibility standard only for antitrust cases. But then, under Iqbal, basically when you read Twombly and Iqbal together, you get this notion of the current standard for 12b-6 in all civil cases, which is plausibility. Okay, so it's a more elevated burden on the plaintiff than prior to Twombly and Iqbal in order to withstand a motion to dismiss. Now, what does that mean? Well, now you're fully edified and able to understand why that footnote is a very big deal, because where's footnote 3? This is only, and I just want everyone to be very clear. I'm going to read this. I know I'm right about this. The defendants have each filed a special motion to dismiss the first amended complaint pursuant to the anti-SLAPP statute, GLC 231-59H. Footnote 3. The defendants have each filed motions to dismiss pursuant to Mass Rule Procedure, Mass Rule of Civil Procedure, paragraph 12b-6. Those motions will be addressed in a separate decision. So, just so everyone understands, he's only ruling on the anti-SLAPP. For the following reasons, the motions are denied. So he's bifurcating. He's combining Aidan and Karen's anti-SLAPP motions into one ruling, and only ruling on that. This ruling has nothing to do with the other part of both Aidan and Karen's motion to dismiss. Why he wrote it this way, I don't know. Maybe he wanted to get it out quickly. It's weird. He should have done them both at the same time. But the point is, the full motion to dismiss is not denied. We don't even know how he ruled on the other part. He gives no indicia of how he ruled on the other part. Maybe he will 16 pages in, but he doesn't in that footnote. And he's specifically using language to rule only on the anti-SLAPP claims. Everyone understand? This has nothing to do with the other half of both Aidan and Karen's motion to dismiss related to 12b-6. It is weirdly only about both Karen and Aidan's anti-SLAPP motions to dismiss. The mind of Judge Gilday, ladies and gentlemen. The mind of Judge Gilday. Okay, let's go back to our reading. All right. Who would have even thought to look for that? Who would have thought to look for that? I didn't. And I somewhat know what I'm doing. What is Iqbal? Oh, great question.
Be addressed in a separate decision.
Hold on. Bunny Towel Mom has a question about Iqbal. It's I-Q-U-B-A-L. IQBAL maybe. You want to Google it. It has to do with expanding the scope of when the elevated standard under Rule 12b-6 for a motion to dismiss comes into play. We're not going to talk about it today because this is not a 12b-6 ruling, it turns out. But just know that when you file a motion to dismiss a civil lawsuit, the person who sued you has to meet a certain level of plausibility on its face, just on the complaint. It has to plausibly allege a complaint, like a violation of a tort, upon which relief can be granted. Okay? Now, we're going to go to the top of page 2. All right, let's go.
So powerful procedural protections were intended to be employed, in a limited context, to ensure the expeditious climation of meritless lawsuits based on petitioning activities alone. 7D. At 555. See Duracraft Corp. versus Holmes Prod. Corp. 427.
Hi, Lorena.
156, 161 to 164, 1998.
I probably do pronounce Twombly wrong. I don't know who told me it the first time. Probably my Civ Pro professor, but the first time you say a name to me, I'm going to remember it that way. It was so hard to say Aidan Kearney's name correctly. Sema. Sema. To say Sema's name correctly, I have to every time say Sema before it. Say Emma and then Sema.
156, 161 to 164, 1998. However, the statute has been regularly invoked in attempts to dismiss a wide array of other claims concerning conduct far afield of the petitioning activity that the legislature originally sought to protect.
Oh, what a kind comment. Attorney O'Leary says, I practice criminal law, but I took civil law and procedure in law school. I just learned more from you than I did in law school regarding those subjects. God bless you. It's my honor to be able to help. Thank you for being here. I appreciate you all.
Legislature originally sought to protect Bristol Asphalt Company, 493 Mass. At 540 to 541. To ensure that a special motion, opponent's own petitioning activity, is not infringed. By the allowance of a special motion to dismiss, the Supreme Judicial Court, SJC, has adopted a two-stage, burden-shifting framework for analyzing the merits of a special motion to dismiss. Filed under GL Circa 231, Section 59H. TD. At 555. See Allegard vs. Harborview Hotel Owner LLC, 497 Mass. 328, 335 to 336, 2026, to prevent these special motions to dismiss, and the powerful procedural protections they afford to litigants from being misused to quell petitioning activity. Our jurisprudence has adopted a necessarily narrow and strict construction of the statute, citation omitted. A party seeking dismissal under the anti-SLAPP statute must make a threshold showing through the pleadings and affidavits that the claims against it are based on the party's petitioning activities alone and have no substantial basis other than or in addition to the petitioning activities, citation omitted.
70 billion bonus points to everyone in the chat for listening attentively.
The petitioning activities, citation omitted. Bristol Asphalt Company, 493 Mass. At 555. HF The special motion proponent cannot make this threshold showing, the motion is denied, and the challenged claim survives. D. However, if the special motion proponent is able to make the threshold showing, the motion will be allowed unless the non-moving party demonstrates that the petitioning activity was devoid of any reasonable factual support or any arguable basis in law, and caused the non-moving party actual injury. J.D. At 557, citing GL Circa 231, Section 59H. As noted, the defendants have separately filed special motions to dismiss under the anti-SLAPP statute, and therefore they each have the initial burden of showing that the claims against them are based on their petitioning activities alone and have no substantial basis other than or in addition to those petitioning activities. Petitioning activity under Section 59H includes 1. Any written or oral statement made before or submitted to a legislative, executive, or judicial body, or any other governmental proceeding. 2. Any written or oral statement made in connection with an issue under consideration or review by a legislative, executive, or judicial body, or any other governmental proceeding. 3. Any statement reasonably likely to encourage consideration or review of an issue by a legislative, executive, or judicial body, or any other governmental proceeding. 4. Any statement reasonably likely to enlist public participation in an effort to effect such consideration. Or 5. Any other statement falling within constitutional protection of the right to petition government. The court concludes that neither defendant has made the threshold showing under the statute. L. Defendant Kearney's initial burden. The plaintiffs assert claims against Kearney for defamation, intentional and negligent infliction of emotional distress, civil conspiracy, and violation of GL Circa 93A. As explained below, Kearney has failed to satisfy his initial burden for two reasons. First, the claims have a substantial basis other than petitioning activity. Second, even if this were not the case, the fact alleges that he was not engaging in petitioning activity on his own behalf, but rather on behalf of read a other substantial basis. Kearney argues that the plaintiff's claims seek to hold him liable for petitioning activity because his statements fall under the second, third, and fourth clauses of GL Circa 231, Section 59H. However, he has failed to establish that this is the case. 1. Defamation claim. The defamation claim is primarily based on Kearney's repeated statements accusing the plaintiffs of murdering Oaks FA and covering it up. Kearney first argues that by publicly accusing the plaintiffs of murder, his statements were reasonably likely to encourage consideration or review of O'Keefe's death by an executive body. However, of all the various places Kearney made these statements, on his livestream, social media platforms, his blog, on plaintiffs' voicemails, at the plaintiffs' homes, and in the case of McCabe, at her daughter's lacrosse game, none were to an executive body, as part of a judicial or other proceeding, or to any authority that could affect consideration of the issue. Cf. Fabra v. Walton, 436 Mass. 517, 523, 2002, filing of a complaint for an abuse protection order and the submission of supporting affidavits of petitioning activities, Diva v. Ward, 92 Mass. App. Court 175, 179, 2017, defendants' appeals to the police and to the courts were quintessential petitioning activity, O'Gara v. Saint-Germain, 91 Mass. App. Court 490, 497, 2017, reporting, suspected criminal activity to the police, was petitioning activity. Kearney cites no case law suggesting that statements to other members of the public accusing someone of murder qualify under this clause of the anti-SLAPP statute. Such statements lack the supplication to higher authority characteristic of petitioning activity under this clause. See Garabedian v. Westland, 59 Mass. App. Court 427, 433, 2003. Kearney next argues his statements are petitioning activity because they were made in
Pause. Nope. Pause. I'm not just taking him at his word. I need to understand what supplication to a higher authority means. You can be damn sure we're going to go find the case he cited. I'm not just taking him at his word. How dare you? How dare you? I will not do that. Let's go.
Connection with
Read this one, please.
John H.G.A.R.A.B.E.D.I.A.N. versus Mary Westland and others, and three
Is this
companion
the right
cases.
one?
Full name, John
Yeah, it is.
H.G.A.R.A.B.E.D.I.A.N. versus Mary Westland and others, and three companion cases. John H.G.A.R.A.B.E.D.I.A.N. versus Mary Westland and others, Note 1, and three companion cases. 59 Mass. App. Court 427. April 11, 2003 to September 26, 2003. Worcester County. Present, PORADA, Cass, and Greenberg, J.J. Anti-SLAPP, statute. Zoning, accessory building or use, private airstrip. Limitations, statute of Latches. Words, incidental use. In an action for a declaration pursuant to GL circa 231A that despite a cease and desist order from the town building commissioner, the plaintiff could, in maintaining and expanding an airplane hangar and a landing strip as an accessory use customarily incidental and subordinate to his residence, bring fill onto his land as a matter of right, and for an injunction restraining interference with that right. A Superior Court judge erred in allowing the special motion of the defendants, the plaintiff's neighbors and vocal opponents of the challenged activities, brought under GL circa 231, S, 59H, the anti-SLAPP statute, to dismiss the complaint. Where such action was not based solely on the petitioning activities of the neighbors, where the petition for declaratory judgment made no claims against a party in the sense contemplated by the anti-SLAPP statute, and where the plaintiff showed by preponderance of evidence that the petitioning activity was devoid of any basis in law and that the defendant's acts had caused actual injury to him. 431 to 434. In a civil action for judicial review under GL circa 40A, S, 17. A Superior Court judge correctly determined that a town zoning board of appeals acted within its discretion in affirming a building inspector's denial of a permit for a second airplane hangar to be constructed at the plaintiff's residence.
What?
And for expansion of the original hangar and airstrip, because such use of the land, which primarily served as the plaintiff's residence, was not a customary and incidental accessory use under the town's zoning by laws, 434 to 436, 438, likewise. The judge properly ruled that the permit-related 6-year limitations period in GL circa 40A, S, 7, barred the plaintiff's neighbors, who knew about the plaintiff's use of the original hangar from the inception of the process, from challenging the use, 436 to 437. In an action brought by the plaintiff's neighbors challenging the plaintiff's use of an airstrip he constructed on his property in 1984, a Superior Court. Page 428. Judge's findings of fact as to latches were not clearly erroneous, where there was evidence that the neighbors remained inactive for 11 years while the plaintiff used, maintained, and improved the airstrip, and acquired airplanes to use on it. 437 to 438. Civil action commenced in the Superior Court Department on March 15, 1996. A special motion to dismiss was heard by James P. Donahue, J., and the case was heard by Francis R. Fecteau, J. John O. Myrick, Patrick L. Davidson with him, for John H. Garabedian. Jonathan Shapiro for Michael Johnston. Barry A. Batrick for Board of Selectmen of Southborough. Gary S. Brackett for Mary Westland. Cass. J. At the center of 4 actions that were consolidated for trial is a controversy over whether John H. Garabedian could maintain and expand an airplane hangar and a landing strip, facilities he described in a letter as my private airport. As an accessory use customarily incidental
I
and
want a
subordinate to his
private
residence.
airport. What?
The parties also dispute whether GL circa 231, section 59H, the anti-SLAPP statute, is applicable to Garabedian's complaint for a declaratory judgment about whether he could bring Philip on his land as matter of right. 1. Facts. We take our facts from the careful and detailed findings of the trial judge. Garabedian, who is in the radio broadcasting business, lives at 24 Fairview Drive, Southborough, a property located in a residential zoning district. He restores and flies classic airplanes as a hobby. Garabedian first acquired a pilot's license in 1976. He flies about 100 hours per year. Until he built his own airstrip.
This is what it's like.
On the basis of...
I can't tell you if Judge is right unless I read this.
In the face
it's
of the
going to be
altercations,
interesting.
the board decided on June 19, 1996, in addition to affirming the building inspector's denial of a permit for Garabedian to build a second hangar, that Garabedian had the right to bring Phil onto his property, albeit subject to restrictions that the board established. From those administrative decisions, Garabedian appealed to the Superior Court in a second action, under GL circa 48, section 17. One aspect of the controversy has been disposed of. A second judge of the Superior Court, i.e., not the one who allowed the anti-SLAPP motion in the declaratory judgment action, decided on Garabedian's summary judgment motion that no bylaw of Southborough precluded Garabedian from filling his land. She ruled that the town could not conjure a restriction on Garabedian's right to fill on the basis of their anticipation that he would attempt to make an unlawful use of the regraded property, i.e., an expanded airstrip with a second hangar. The town officials and Johnston and Westland appealed to this court, and we, in an unpublished memorandum and order under our Rule 1-28, affirmed the reasoning and decision of the Page 431. Superior Court Judge. C. Garabedian vs. Zoning Board of Appeals of Southborough, 52 Mass. App. Court 1101. That left before a third Superior Court Judge the following matters for consolidated trial. Review. Dismissal of declaratory judgment complaint under anti-SLAPP statute. Opposition activity to Garabedian's earth-moving operations had come from certain of his neighbors, notably Johnston and Westland. They told drivers of trucks bringing in fill that the drivers were engaged in an illegal operation and might be liable for what they were doing. Johnston, a television cameraman, photographed trucks, an act that the grading contractor thought sufficiently hostile and intimidating to warrant reciprocation in the form of beating up Johnston and taking his camera.
What?
There was also, ultimately, official action in the form of the building inspector's cease and desist order. In that venomous and unstable setting, Garabedian filed his complaint for a declaration, pursuant to GL circa 231A, that he, Page 432, could bring Phil onto his land as a matter of right, and for an injunction restraining interference with that right. The complaint states that Garabedian had received a cease and desist order from the building commissioner. Orders of public officials are not generally appropriate subject matter for declaratory judgment, if, as in the case of a building inspector, there are administrative remedies to exhaust. None of the defendants has raised the point, however, and, in any event, the complaint for declaratory judgment directs itself materially to the private challenges against Garabedian's project. As noted, a judge of the Superior Court allowed the special motion of Johnston and Westland brought under GL circa 231, section 59H, to dismiss the complaint. Some of the challenges thrown up by the defendants Johnston and Westland to Garabedian had the character of petitioning activity, as that has been described in the anti-SLAPP statute, GL circa 231, section 59H, and by decisional law interpreting that statute. They had made representations to town and state officials in hope of obtaining public intervention in Garabedian's landfilling work. They had summoned police, they had leafleted the neighborhood to encourage opposition at public meetings, and they had organized residents to attend public meetings. Other aspects of their intervention, however, were private and lacked the characteristics of petition, namely the harassing of Garabedian's contractor and the somewhat intrusive surveillance of Garabedian's activity. A motion to...
Wait! The things that Judge is comparing what Aidan did to the... First of all, this dude's contractor beat this guy up, and then this guy still managed to win. These guys were protesting this dude building a private airport on his property for just him to use. And they go protesting their contractor building the airport for Garabedian beats up the guys protesting him, and Garabedian still wins. Oh, God. But the other thing, for our purposes, so, like, the appellate courts called, like, going up to the contractor and saying, like, this project is illegal, harassing. And then, which wouldn't be the definition under the current case law of harassment. And then it says there was intrusive surveillance, somewhat intrusive surveillance of the property. Okay, well, if those are the two things in this case, if that's the only two things in this precedent that are outside the scope of petitioning activity, then I think we might need another look at this one.
A motion to dismiss under GL Circa 231, Section 59H, lies if the movement shows that the plaintiff's claims are based on the petitioning activities of the movement alone and have no substantial basis beyond those activities.
The case law has evolved since then, but that's basically it.
Petitions, by definition, are addressed to page 433. Someone. The direct action of the individual defendants on the ground, involving Garabedian's grading contractor, the proclamations and warnings to the contractor's truck drivers, and the picture taking, were activities based on assertions by the neighbors of a legal position and involved no supplication to higher authority.
Here's what we want. Supplication to higher authority. Winner. Oh, a gold trophy. What an amazing gold trophy. Thank you so much to Curly Girl. That was so nice of you. A trophy cake. I've always wanted a cake based on a trophy. That's great. God bless you. You're wonderful.
Were activities based on assertions by the neighbors of a legal position and involved no supplication to higher authority.
Supplication to higher
Note
authority.
5. The target of those activities was Garabedian. His declaratory judgment action...
Wait a minute! The target of those activities was Garabedian?
His declaratory judgment action, therefore, was not based alone on the petitioning activities of the neighbors. Contrast McDonald versus Patton, 57 Mass. For that reason, if no other, the motion to dismiss should not have been allowed, and there were other reasons to have denied it. A complaint for a declaratory judgment is the least aggressive of complaints. Its purpose is to remove, and to afford relief from, uncertainty and insecurity with respect to right, duties, status and other legal relations.
We don't need to worry about that. We're only interested in the anti-slap.
A third reason to have denied the Section 59H motion to dismiss is that such a motion shall not be granted if the non-moving party shows by a preponderance of evidence that the petitioning activity is devoid of any arguable basis in law, and the moving party's acts caused actual injury to the responding party. GL Circa 231, Section 59H. See Baker v. Parsons, 434 Mass. At 552 to 555. There was no showing of a basis, in the bylaws of Southborough or elsewhere, to regulate the kind of landfilling that Garabedian was carrying on. The Board of Appeals of Southborough conceded as much in the summary judgment proceedings that resulted in a ruling in Superior Court, affirmed on appeal, that as Garabedian's land was neither in a floodplain district nor contained a wetland. No statutory prohibition limited Garabedian's right to place fill on his property to equalize the grade.
That's not really relevant to our case that we're reading, because here what they're saying is, listen, they were saying this guy was doing illegal things by building this airport hangar, and there was no law that prevented him from building his airport hangar. They relied on a denial of a permit by someone at the Zoning Board of Appeals to, like, go tell contractors not to go work with this guy because the project could be illegal. And the ruling here is that doing that and relying on the Zoning Board of Appeals, like, denial of a permit is not petitioning activity, in particular because what the guy was doing, just because his permit got denied, wasn't illegal. That's not what we have here at all. I get, like, the judge is citing this, or his clerk, for, oh, it's a flying eagle, look at it, that was great. I get that what the judge is, his clerk is trying to point out here is, like, you have to have some kind of supplication to authority. Well, yeah, okay, but that's not really the primary holding here. The primary holding here is that you can't argue someone broke a law and go petition their contractors for redress of your grievances when the only thing they did was get a denial of their permit. And there was no law prohibiting them from building an airport hangar. That's not what we're talking about here. And the notion of this case standing for the appellate concept of supplication to authority hinges on the fact that they were wrong. Not wrong about who did it. They were wrong about whether the guy could build the airport hangar. That's just not what... Oh, God. Oh, this has already gone off the rails. I told you. You got to read it sometimes. You can't just think that the judge is going to do what he's got to do. All right, I have a lot of trouble with that reasoning. If that's the
Commonwealth
case,
of Massachusetts.
if what judge is citing for as a characteristic of supplication to higher authority petitioning activity is Garabedian v. Westland, I got a lot of questions. Because what Judge is saying here is the reason why TurtleBoy was not engaged in petitioning activity under one specific clause related to a necessary component that relates to supplication to higher authority, like trying to make an argument to a body that is a part of government or like able to make decisions to enforce a law. And Judge is like, listen, the characteristic petitioning activity that you'd see in the context of supplication to higher authority is defined by Garabedian v. Westland. Well, if you look at Garabedian v. Westland, they differentiate the appellate court. It's the appellate court differentiates a little bit between like gathering neighbors to go like protest at a zoning board and then like going up to a contractor. But once you get into like what they went up to the contractor and said, like the reason they had no ability to have a supplication to a higher authority is their basis for protesting that man, Garabedian, building his private airport was wrong. There was no basis in law. It was just a denial of a permit. So this idea that Garabedian v. Westland is this like expansive explication by the appellate court of what supplication to higher authority is wrong. That the court did not take a lot of time at all to think about that. It was a tangential issue at best to whether or not the neighbors who were protesting Garabedian were doing so on the basis of an administrative denial of a zoning permit with no basis in law to allege that the building of the airport was illegal. Which is not really what Judge is citing it for at all. He's missing the mark by a lot, in fact. It does have the words supplication to higher authority in it. It does have that somewhat defined, but it is not to cite that and suggest that therefore like you have an expansive review of what GLC 23159H requires in the context of supplication to higher authority is just nonsensical. I mean, it's ripe for appeal and we're 4 pages in. So let's continue. Where were we now? We were at the bottom of page 3 and we were going to start with Kearney next argues his statements are petitioning activity.
Kearney next argues his statements are petitioning activity.
Listen, I think a clerk is about to have a really bad day.
Kearney next argues his statements are petitioning activity because they were made in connection with an issue under consideration or review by a legislative, executive, or judicial body, namely, the investigation into O'Keefe's death and the prosecution of Karen Reed. GL circa 231, section 59H. The SIC has stated that for statements to qualify under this clause of the anti-SLAPP statute, there must be a plausible nexus between the statement and the governmental proceeding. Blanchard vs. Stewart Kearney Hospital, Inner, 477 Mass. 141, 149, 2017, overruled. On other grounds by Bristol, 493 Mass. At 552 to 554. To assess if this plausible nexus exists, the SJC analyzes objective indicia of a party's intent to influence a governmental proceeding, such as the timing, audience, and content of the statement. Blakesley vs. Marcus, 158 F. 4th 90, 99, 1st CIR. 2025. The communications must be closely and rationally related to the governmental proceedings. Plant vs. Wiley, 63 Mass. App. Court 151, 159, 2005, and made to influence, inform, or at the very least, reach government bodies, either directly or indirectly. Citation omitted. North American Expositions Company Limited, Partnership vs. Corcoran, 452 Mass. 852, 862, 2009. Pipe. Although some of Kearney's statements at least tangentially relate to an issue there was under judicial review, i.e., the prosecution of Karen Reed, the claims largely target statements that do not have a plausible nexus to this prosecution.
What?
The statements are directed toward viewers and potential viewers of Kearney's live stream and readers of his blog and their content. Does not seek to influence government action in any way. See Lucy versus Kinnan, 106 Mass.
Wait a minute. One of the people who was like a prolific reader of Aidan's blogs was the U.S. Attorney's Office. Oh, God bless you, Daphne. Wait a minute. This is just wrong as a matter of fact. And in that phone extraction, or that computer, whatever it was, that was taken from Aidan and then laundered for evidentiary use in like the public sphere and whatever, that actually helps Aidan here. Listen, Dustin Chow, the U.S. Attorney, the head of the public corruption section at the U.S. Attorney's Office in Boston, literally was telling Aidan that the office was reading his stuff. Multiple prosecutions have derived from Aidan Kearney's coverage. Monica Cannon-Grant, although I'm still not voting for Rachel Rollins. No way. It's bad news. Should have been charged criminally, in my opinion. The DOJ OIG referred her for criminal charges. She only got out of it because she knew Biden's wife, in my opinion. I don't play that game. Damn Democrats. Commies, in my opinion. A lot of them. Anyway, TurtleBoy had 10% of the U.S. Attorney's Office in Boston reading his articles and generating cases. He knew he's going to be able to prove that while he was writing this stuff, listen, this is going to go down a weird road. He's going to be able to prove that while he was writing this stuff, he was thinking, oh yeah, the feds are going to be reading this. And that's at the very least. You ever look into Steve Miller and Buffalo Jim? Actually, Judge Gilday might not like where this is going to end up going. News production, like maybe done like 10 years ago. Now listen, if you know anything about Buffalo Jim's wrestling school and the Crazy Horse 2 strip club, I'm about to blow your mind. Okay? You're never going to believe this, but it exists. It's real. If I did not have this primary source, you would not believe me. But let me just say, Judge Gilday may have just walked into, I don't know what the feds are going to want to do about this, but yeah, you might want to, take a listen to this. Where's this doc? Ah, yes, here we go. Ah, yes, indeed, I have it for you. It's just a short clip. I'm very good at just finding things, all right? All right, here you go. Let's take a look at this clip. It's just 3 minutes. Let me know what you think.
Was also playing offense, and he was playing for the FBI.
The feds came in and completely usurped the local police department investigation, which was going backwards, not even forwards. Nobody quite ever figured out what was going on, and now, of course, I can talk about both Buffalo and I were confidential informants for the FBI. And that started in 2002, and it lasted through 2007, the day the place was closed. And the confidentiality part is for 7 years, approximately.
So now you can talk about it.
Oh, yeah.
Well past that.
Absolutely. But for the 7 years that we were on contract with the FBI, so it wasn't a matter of just, I can't talk. I mean, I don't think I'd go to jail, but I could get in a lot of trouble. You're not allowed to talk.
Yeah. In 2003, the Crazy Horse 2 was raided by the FBI.
And so I was thrilled when I saw the feds step in. The police were told, butt out. When the feds had their raid, I was told about it because they wanted me to cover it, nobody else. I later found out what the real basis of the raid was. Can't believe this story either when I tell you, but I will. They were there for only one reason, was to plant electronics. It was supposedly on the premise of drugs and guns. That wasn't why.
That was all a cover.
That was the cover. Yeah, that was the cover. And they were there. They planted so much electronics in there. It's cutting edge. I mean, only the feds would have what they had. That place was wired for the next 5 years.
This was the beginning of the end for Rick Rizzolo and the Crazy Horse 2. Over the next few years, the FBI, with the help of Buffalo Jim and Steve, surveilled and investigated the Crazy Horse 2 and its associates.
So my dad was a credible source to them.
Yeah.
When my dad said something occurred, it actually occurred.
Yeah.
But my dad would send in information to them, and I was told that it was very helpful.
My column was
Wait, listen to this part. I want you to think about the summer of 2023. all of you. And I want you to listen to this like you're reading Great Expectations for the second time. What this man's about to say, not what the daughter says. She's pretty cool, though.
Them, and I was told that it was very helpful.
My column was completely vetted by the FBI on a weekly basis, and that I would see things there that I thought were kind of interesting. They had how many places, how many links were there to my personal email address throughout. 10 maybe in each column. I didn't put them there. And all of a sudden, on Google and Bing and all the various search engines, if you type in Crazy Horse 2, here comes my column on the top. The next column, the next column. I mean, I'm taking up pages. So I begun to ask around, you know, and the guys laughed and they said, yeah, we took care of that for you. You're famous. Okay, so I said, what am I supposed to do? I'm getting all these emails, you know, people got beat up, they got this and that. He says, okay, that's what we want you to do. That's why we put you in there. He says, if it sounds legit, you got to call me 24/7. And he says, and you give me the name of the person, give me a little scenario as to what they told you happened and their phone number. And we'll get right back to him. He says, you got to tell them they're going to get a call from a guy named Bobby. He's a federal agent. Well, 13 people in the next couple of years, that's as many as I was credited for, emailed me. And they were the federal witnesses.
Rick and the people who had interest in protecting the Crazy Horse 2 may not have known Jim was working directly with the FBI, but they did know that he was a threat.
Fascinating. I didn't know the FBI edits like freelance columnists and bloggers blog posts to generate tips and leads. Who knew? Who knew? Well, I knew. Hey, I'm into the Attitude Era, the WWF. Of course I was going to watch like a 4-hour documentary about Buffalo Jim. I love the Attitude Era. And of course I was going to come across that random 30-second clip that, you know, once a Fed tactic, always a Fed tactic. Yeah. These people, I'm telling you, not just Judge Gilday, a lot of people don't realize what they're walking into. And this is what, petitioning activity. Okay. All right. Okay. Okay. Listen, I don't know how... Listen, I don't think the feds are going to ever let him just say it. But this is outrageous. Like, hit the whole point of everything he was doing was to drive not just attention, but to actually get people prosecuted.
See Lucy versus Kinnan, 106 Mass. App. Court 358, 366, 2025. Personnel directed to the government, and that did not mention any. Government proceeding, but rather consisted of throwing barbs, but another was not petitioning.
Wait, what?
Activity.
What?
Rather.
Hold on.
Court 358. The statements are directed toward viewers and potential viewers of Kearney's live stream and readers of his blog and their content. Does not seek to influence government action in any way.
In any way? In any way? Oh my god. I bet Dustin Chow read this and was like, what? You listen, you think you're on the ball? Wait till you meet the DOJ. Oh my god. The scariest thing you've ever seen. They know everything immediately. They know things before they happen, bro. They're that good. So, they probably read this and were like, oh god, this has created a bit of a, cluster F. Oh, God bless you, Nicolor. I'm so happy that I was able to do so. Hold on. Let me give you a wrench, and then let me say thank you. Some people... I noticed that it is helpful on fast chats to do the super chats at the end, but I don't like to do that. I prefer to do them in real time. So I just pray your indulgence when super chats come up. I like to just recognize them in real time. So I am a Tao. Thank you for your indulgence. All right, let's continue.
See Lucy versus Kinnan, 106 Mass. App. Court 358, 366, 2025. Personnel directed to the government, and that did not mention any. Government proceeding, but rather consisted of throwing barbs, but another was not petitioning.
Oh, yeah?
Activity.
Let's see
Rather,
about that.
the statements are aimed at convincing Kearney's audience to regard and treat the plaintiffs as murderers. See, e.g., Fac Para. 56. Jennifer McCabe and Brian Albert are involved. They're covering it up. ... The McCabe's have the look of evil in them when you see them in person. These are people with no shame, and aren't the least bit deterred by the fact that millions of people know that they participated in a murder and subsequent cover-up of a murder of a Boston police officer, Fact Para. 59, Jen and Matt McCabe do not deserve to live a normal life and pretend that they weren't involved in murdering a Boston police officer, Fact at Para. 90, calling McCabe a cop killing pig. Such statements are markedly different than those the courts have concluded are made in connection with a proceeding under judicial or executive review. See Wynn vs. Craigle, 63 Mass. App. Court 246, 254, 2005, Statements 2. Media by firefighter's widow was sufficiently tied to her and in advancement of her petition for benefits under consideration by the legislature and were mirror images of what she had reported to government Betty. The FAC also cites allegedly defamatory statements Kearney made after the second trial had ended and therefore not connected to any issue under judicial review.
Oh, God! Oh, no! Oh, no! Oh, yeah, this is getting appealed. This is a way too early order. First of all, how would you know, Judge, what is under investigation right now and what is not? Nobody knows. Certainly not anyone without some very high-level DOJ clearances. So what are you talking about? Oh, wow. Oh, goodness. This is going to become quite a... Listen, this ruling... Here's the thing. Say there were, hypothetically, like secret proceedings related to any number of things, not even at the grand jury stage, just an investigation. And it were to come out ex post facto. So say the investigation were ongoing during the time, the operative period of time this ruling were about. What are you talking about? This is absurd. There were law enforcement interviews in the Matthew Farwell and Sandra Birchmore case. I'm talking about DOJ interviewing through their whoever, partners, or maybe themselves, AUSAs, who knows. According to the Birchmore filings in the Farwell case, there were DOJ interviews of law enforcement personnel in the Commonwealth in April of 2026. Okay? So what is Judge Gilday talking about? I don't know anything either way. All I know is in a hypothetical world, which is plausible, more than plausible, possible. There is a situation where there is an investigation that is ongoing and was ongoing after the second trial. How can you make this ruling? How can you state that so definitively? Your ruling might not be valid. The logic is invalid. Jody says, thank you for bringing us up to speed. Thank you for bringing all of this up on Melanie's... Oh, hold on. Thank you for bringing all of this up on Attorney Melanie Little's Live. Many of us were gobsmacked. You're brilliant. Oh, I think you're all brilliant and wonderful. God bless all of you. Thank you for your support of Towel Channel. We're possibly going to get some goat videos, you know. Nothing wrong with some goat videos during a court motion. Judge Gilday needs to see some goat videos. He apparently likes the YouTube. You know, I imagine he's watching. He's sitting there. It's Friday. He's in Plymouth Superior Court. It's hot. The parking lot's scorching. He probably wants to go home, sit in the air conditioning, watch Matlock. I like Matlock. I'd watch it with him. Hashtag Matlock. Anyway, so my point is, it's one thing if he were just getting it wrong, but he's basing his entire decision on a record that I don't even know if he is complete historically, or if he has access to. Hashtag let's go watch Matlock. I'm never practicing in this state, or really anywhere, so, ha!
C, e.g., FAC at Paris. 125 to 126, 132 to 133, 135, 138.4 CF.
T.A. Sarah, 1 trillion bonus points to everyone in the chat who liked Murder, She Wrote or knew what Matlock was.
125 to 126, 132 to 133, 135, 138.4 CF. Plant, 63 Mass. App. Court, at 159, settlement demand made to resolve disputed issue under review by Planning Board was made in connection with pending governmental proceeding. That, Kearney's statements concern a topic that has attracted governmental attention in itself does not give them the Character contemplated by the statute. Global Naps, Inc. versus Verizon New England, Inc. 63. Mass. App. Court 600, 605, 2005.
Pause. Pause. We got some cases to review. Pause. Nope. Nope. I don't take anybody at their word. Nope. Not a chance. We're going to go read them. You heard me. We're going to read them. I don't trust nobody. All right. Here we go. All right. So what's the first one? What's the first one? Let me see here. All right. It was Wynn versus Kregel. What a name. No, it was Lucy versus Kennan, actually, was the first one he cited. All right. And he Judge Gilday says, the post not directed to government and that did not mention any government proceeding, but rather consisted of throwing barbs at another, was not petitioning activity. Okay, explain to me how talking about the death of John O'Keefe does not encompass, per se, governmental proceedings. By the way, wasn't there a civil lawsuit active? Notwithstanding the end of the second criminal trial, this ruling's wrong. Whether it's right or wrong, I'm not, like whether it's fully right or wrong in light of the accurate record, I don't know. I gotta look at all of these citations. But I'm telling you right now, 5 pages in, it needs to be looked at. It's going to be appealed no matter what. I'm not a lawyer. This is not legal advice, but this is ridiculous. This is absurd. So now we're going to go look at Lucy v. Kinnan to see if the statements made there are tantamount to the statements that Aidan made about the John O'Keefe and Karen Reed trial. All right, we're going to listen to it. Howard Cooper. Howard Cooper. I know that name. Howard
Court.
Cooper. I don't know why.
Lucy versus Kinnan.
Maybe Howard Cooper. Did he represent Shannon O'Brien? I thought that guy's name was Max. Yeah, that guy's name is Max. And that was Max Stern. I don't know why I know the name Howard Cooper. For some reason, I know a lawyer, or at least I was covering a case where a lawyer was named Howard Cooper. I don't know why. I'm going to have to figure this out. Normally I just know things, but that's really obscure. He's like a business litigator, I want to say. I don't know why. Maybe he came up in see, I cover a lot of obscure zoning debate, like lawsuits or corporate litigation. So I see all sorts of legal names, and that's just one I remember. Blessed Texas Lolly says, Grant, you're the brilliance we all needed for a while. Thank you for doing this for the community. Oh, God bless you. It's my pleasure. I just try to help as I can. I want to be a Southern man. I also am a Northern man. As Kevin from South Boston and Standing Stone say, I'm a Northern man with a South Boston accent. All right? And sometimes I become a Southern man, depending on the day of the week.
Lucy versus Kinnan, 20.
Someone asked, by the way, earlier when I sleep. I sleep Wednesdays between 8 and 11 p.m. Eastern.
Lucy versus.
Oh, Stacy CB says, first ever super chat on YouTube, and you deserve it. Well, God bless you, Stacy CB. You have a wrench now, too, and I will consider this a distinct honor and privilege, and you are now a towel forevermore. I'm glad you found it helpful. You're all wonderful. I'm going to screenshot your first ever super chat. That's great. You're wonderful. So, we need to see whether the statements in Lucy v. Kinnan are actually the same as talking about a unsolved crime, basically.
Lucy versus Kinnan, 2025. Appeals Court of Massachusetts.
Neil Kinnan? Wait a minute. The guy from Malden? Well, you don't understand. First of all, I'm more Republican now, but I know Mr. Kinnan. I call him Mr. Kinnan. I have been in that Facebook group. Wait a minute. I've been in that Facebook group for 9 years. I didn't know there was a lawsuit about it. No wonder why. So, listen, you don't understand. For a long time, I was liberal and young. Now I'm a little bit far more Republican. So I was the only liberal they used to allow in that group. Because I was very respectful to my elders, even all the time. So I would refer to, Mr. Kinnan and there's some really cool guys and girls in that group. But my point is, I'm in this Facebook group. This is the most ridiculous freaking thing I've ever seen. Okay. I can't believe this is happening right This is hilarious. Oh my god. Oh my god. Oh my god. They have this group like Penny for Your Thoughts, Malden. Oh my god. Attorney O'Leary says, loved you on Attorney Melanie Little's trial grant. Very smart. I had to keep rewinding to take in everything you were saying. Keep doing what you're doing. It's wonderful. Oh, God bless you. I absolutely will, Attorney O'Leary. Thank you for your support. And I must say, somebody must think I'm doing something right. Because somehow, through 6 degrees of towel bacon, I am 2 degrees removed from the case Judge Gilday cited. What is going on here? This is outrageous. Holly Mack says, donating all the way from Cape Breton Island, Nova Scotia. Enjoyed you on Melanie, so came over to subscribe. Well, I hope you have enjoyed your first stream. It has certainly been a whirlwind, Holly Mack, and enjoy your towel wrench. I'm not making this up. I legitimately know Mr. Kinnan, and I have for like 9 years. And what's funny is, a lot of people, this is how I knew Republicans were okay. A lot of people would say Republicans were completely intolerant of liberals, but they let me hang out even when I was I don't know, much younger and much more liberal. They were like, well, Grant's okay. Grant can be the one, liberal voice. Now I'm way more Republican. They don't have to worry about me at all. Sub Rosa says, I just sent you a fluffy goat hat design on Facebook Messenger, and now we're all about penguins. Oh, so I just want to say I don't check all my in-block boxes. God bless you, Sub Rosa. If you ever want me to see something immediately, within a week, it's going to be grantsmithellis@gmail, no spaces. So that's the quickest way to get my attention. Now, with that quick, hilarious interlude there, we need to actually see if this... Oh, God, this is going to be ridiculous, I can already tell you. These Malden Facebook groups, they're great, but they're ridiculous. We have to find out if what the people saying in the Malden Facebook groups was actually completely unrelated to a, governmental, activity or function or proceeding.
Appeals Court of Massachusetts. Scott. The defendant Neil Kinnan insulted the plaintiff, Scott Lucy, on the webpage for a Facebook group known as Malden, M.A., Politics. Specifically, in responding to a comment that Lucy had posted on June 7, 2023, Kinnan stated, I'm beginning to wonder if you are capable of reading. Might want to read again, and anybody who would hire you to be their attorney, God bless them, because someone must have taken the bar exam for you, emphasis added. Lucy brought this defamation action against Kinnan, claiming that the emphasized words constituted an injurious, false statement of fact. In response, Kinnan filed 2 motions to dismiss. In the first motion, under Mass. RCIV. P. 12B6 300.
I'm not going to do the 12B6 analysis, but I want to say thank you for helping us reach this super chat goal. Mr. Monk's understudy asks, how is Kevin Collins still employed at the Boston Globe? I know, after that Boston Marathon thing. Plus, he's from Malden. Yeah, small world. But yeah, take a look at that. God bless you all. We did it. I will absolutely play goat videos. You have achieved your goal. What a wonderful day to be. Well, you're also generous. We're going to start another one. I'll give you bonus goat videos. You're great. Thank you for supporting Towel News. Oh, another one. It came in before. I wanted to be 10 out of 10 on your goal. Oh, Attorney O'Leary, you were so close. God bless you. There is no shortage of support for Towel Channel. Towel News. Apparently, you all find this very helpful. You will be number 10 in spirit, Attorney O'Leary. You are an honorary towel forevermore, elevated to super towel status. All right, so we don't want to listen to the 12B6 analysis. We want to listen to this.
In the second motion, under the Anti-SLAPP Statute, GL Circa 231, Section 59H, Kinnan argued that his statement was protected petitioning activity. In that the statement was made as part of a communication intended to influence the actions of the Malden City Council with respect to pending zoning legislation. A Superior Court judge dismissed Lucy's complaint pursuant to Rule 12b6 and also denied Kinnan's motion under the Anti-SLAPP Statute.
Okay, so the statement in question here is, I'm beginning to wonder if you are capable of reading. Might want to read again, and anybody who would hire you to be their attorney, God bless them, because someone must have taken the bar exam for you. Oh, okay? I mean, that's... I'm a little bit confused about what that has to do with a court proceeding. I get they were... But it's more about the person's qualifications. It's not saying, therefore, you are guilty of violating Malden Zoning Ordinance 50.4b, and I demand you be investigated by the federal government. It doesn't really go there. It's a little bit more, general. All right, let's go to the 12b6 analysis. All right, maybe there's a little bit more here. Let's read the background.
Background. According to Lucy's complaint, Lucy and Kinnan have known each other for years, and Kinnan had insulted Lucy at other times before the events in question. Kinnan is a former Malden city councillor, and Lucy, an attorney, had been a frequent participant in Malden political discussions. As of June of 2023, both were members of the Facebook group Malden, MA, Politics. As described by Lucy in his complaint, the group serves as a forum for discussion of local events and political issues relevant to Malden and the surrounding area. In June of 2023, Kinnan and Lucy made a total of 4 relevant posts regarding an upcoming public hearing of the Malden City Council, having to do with some proposed zoning changes. Kinnan posted, "Troubling when one of the most important public hearings, which could potentially transform the city of Malden's future in a way which ignores the vast majority of citizens' message just a few years back. Adding thousands of apartment units and people to our already overcrowded city and underfunded K-8 schools has barely been promoted by our city councillors and mayor. Tonight 6 p.m. at City Council Chambers. June 7th, right before summer break. For anybody who understands the city council operations, this is not an accident." Lucy then posted, "You'd almost think the original poster was never a city councillor and never took the same summer break now criticizing." Eerie. Kinnan responded, "I'm beginning to wonder if you are capable of reading. Might want to read again, and anybody who would hire you to be their attorney, God bless them, because someone must have taken the bar exam for you. Read below as well for my answer to Mr. Bernstein, it might help you." Finally, Lucy responded, "God bless a client of mine. Why did they sneeze?" Approximately 5 months later, in November of 2023, Lucy filed this complaint for defamation. He alleged that Kinnan's statement that someone must have taken the bar exam for him was made and published by Kinnan knowing that the statement was false or with reckless disregard for its lack of truth, and that the wording of the statement was such as to be an assertion of fact and not one of opinion. The complaint further alleged that Kinnan's statement could be damaging to Lucy's reputation in the community as well as his standing within his profession. A Superior Court judge dismissed the claim, ruling as a matter of law that viewed in context, Kinnan did not make a false statement of fact. At the same time, the judge denied Kinnan's motion to dismiss under the anti-SLAPP statute, concluding that Lucy's defamation action was not based on Kinnan's petitioning activities alone. Both rulings are now before us, the parties having cross-appealed.
So he won on summary judgment, lost on the... He won on summary judgment, lost on the anti-SLAPP, and appealed the loss on the anti-SLAPP, and the other guy appealed the loss on summary judgment. Oh God, why do we do this to the courts? It's great. I personally think it's edifying, but the judges must be bashing their heads on the walls.
Discussion.
Well,
1.
You can't accuse the appellate court of not being familiar with Facebook, let's put it that way.
The defamation claim. Lucy's defamation claim need not long detain us. To establish a...
Okay, I don't need that, Red.
Lucy
I'm
versus...
sorry. I need to go a little bit further down. We need to go to the anti-SLAPP. Thank you. Number 2. There we go. Thank you. I just want to say, I don't want to be an appellate court judge. Thank you.
The anti-SLAPP motion. Kinnan's anti-SLAPP motion presents a more substantial question. The motion judge denied the motion, reasoning that Lucy's defamation action was not based solely on Kinnan's petitioning activity.
Here we go.
On appeal, Kinnan insists that the statement at issue qualifies as petitioning activity, relying on the anti-SLAPP statute's broad definition of a party's exercise of its right of petition. GL circa 231, section 59H. Relying on that express definition, Kinnan argues that his statement, "Someone must have taken the bar exam for you," was made in connection with an issue under consideration by a legislative body or governmental proceeding, and or that it was reasonably likely to enlist public participation in an effort to effect such consideration, emphasis added. It appears to be Kinnan's view that, because he started the chain of posts with a statement directed to an issue before a legislative body, the posts that followed all should be considered as made in connection with his petitioning activity. The operative facts are not in dispute, and thus the question whether Kinnan's statement qualifies as the exercise of his right of petition under GL circa 231, section 59H, presents as a question of law.
Not a fact.
See Bristol Asphalt Company, Inc. versus Rochester Bituminous Prods, Inc., 493 Mass. It is true, as Kinnan argues, that the statute defines the exercise of petitioning rights broadly. The definition is set forth in full in the margin. However, as is often the case when the words "in connection with" are used to describe scope, the definition is in need of further construction to establish its limits.
Makes sense.
C. E.g. Outfront Media LLC versus Assessors of Boston. 811, 815 to 820, 231 NE 3D 313, 2024. Further defining words, in connection with, is used in statute governing tax exemptions for property owned by Massachusetts Bay Transportation Authority. See also Daddario versus Daddario, 75 F 4th 86, 95 to 96, 2D. Coleman versus Zanford, 535 U.S. 813, 820, 122 S. Court. 1899, 153 LED.2D1, 2002, Federal Securities Statutes, in connection with, language, must not be construed so broadly as to convert every common law. Here, the anti-SLAPP statute's definition of petitioning has been further defined and limited by the Supreme Judicial Court. In Blanchard versus Stewart Kearney Hospital, Inc., 477 Mass. 100, 200, 130, at 551 to 556, 227 NE 3D 1019, the court considered whether the anti-SLAPP statute applied to two different types of statements made by a hospital president that allegedly defamed certain hospital employees who worked in the hospital's adolescent psychiatric unit. At the time the hospital president made the allegedly defamatory statements, the hospital unit was under investigation by the State's Department of Mental Health, DMH. Blanchard I, Supra 144 to 145, 75 NE 3D 21. The first type of statement was made to, and published by, the Boston Globe. The second type was an internal email message to all employees at the hospital, which advised them that after a thorough investigation, the hospital president had determined that a number of hospital staff had not demonstrated a steadfast commitment to patient care, and hence had been terminated. Id. In response to the employee's defamation action, the hospital defendants invoked the anti-SLAPP statute, arguing that each of the statements was made in connection with an issue under review by an executive body. Id. At 148, 75 NE 3D 21. The hospital's position was that because DMH was at the time considering whether to revoke the hospital's license, each of the president's statements was part of the hospital's efforts to maintain its license by demonstrating to DMH that it was taking remedial steps. Id. The Supreme Judicial Court, however, agreed only in part. Id. At 149 to 153, 75 NE 3D 21. The court held that the statements to the Boston Globe qualified as protected petitioning, because the evidence showed that those statements were intended to demonstrate to DMH the hospital's public commitment to address the underlying problems at the unit. Id. At 150, 75 NE 3D 21. The internal email did not qualify as petitioning activity, however, because nothing in the content of the email suggests any audience for the message other than hospital employees. Id. At 151, 75 NE 3D 21.
This is what we want.
A private statement to a select group of people does not, without more, establish a plausible nexus to a governmental proceeding.
Wait a minute! Wait a minute! Judge Gilday is comparing Aidan's articles to a private email sent to hospital employees? Oh yeah. Oh, we got another one. Do you understand? So Judge here is, we got to listen to more of it, but Judge here is relying on a case wherein the speech that was considered not to be petitioning activity because it lacked a nexus to a matter under consideration by an executive body was a private email to employees, not publicly published. And that's Judge Gilday's basis. I'm all mad. That's it. Oh yeah. And another one. You know what I'm saying? Now we got another one. Who wrote this? Listen, you know what? There's a reason why Jürgen Habermas's critique of legal rationality is that judges and lawyers use ends justify the means reasoning to reach their conclusions. They reach a conclusion and try to fit precedent to make it justify it. This is nonsensical. If this were a Jenga tower, it would have fallen over like it were guarding the Strait of Hormuz. You understand this decision? It looks that's what makes me so mad. It looks superficially like he's making a valid argument. When you read the decisions, it's not a valid argument. I'm getting all mad. You don't understand? I'm telling you. You can't compare blog posts to a private email sent to employees of a hospital. That's what you'd call distinguished. You distinguish one set of facts from the other set of facts and then render a conclusion of law based on the operative facts. You know what I'm saying? I thought that's why we had a constitution. What's the point of all of this? I'm mad. Somebody put me in elected office and let me yell at these judges.
A private statement to a select group of people does not, without more, establish a plausible nexus to a governmental proceeding. Id.
It wasn't a private statement.
75 NE 3D 21. The Blanchard I Court's analysis is instructive in analyzing the question presented here. Most fundamentally, the Court's analysis recognizes that although the statutory definition is broad, it has limits. The language must be read consistently with the anti-SLAPP statute's intended purpose, which is to protect statements that are intended to seek redress from the government. See id. At 147 to 149, 75 NE 3D 21. That is the language of the First Amendment to the United States Constitution. It protects the right to petition the government for a redress of grievances, emphasis added. See Blanchard I, supra at 157 to 158 and N.24, 75 NE 3D 21. Consistent with that purpose, the Blanchard I Court construed the anti-SLAPP statutes, in connection with definition as requiring a communication made to influence, inform, or at the very least, reach governmental bodies, either directly or indirectly, citation omitted.
No shit.
Blanchard
No.
I, 477 Mass.
No.
149, 75 NE 3D 21.
No. What? Yeah. Yeah. No, a private email can't do that. You're right.
At 149,
That's true.
75 NE 3D 21. The court continued. The archetypical demonstration of this nexus involves a party's statement regarding an ongoing government...
The archetypal demonstration of this nexus, and you all think I like to waffle. Welcome to the Massachusetts Appellate Court.
The archetypical demonstration of this nexus involves a party's statement regarding an ongoing governmental proceeding made directly to a governmental body. Failing something this clear-cut, courts look to objective indicia of a party's intent to influence a governmental proceeding. This intent to influence is manifested in statements that are closely and rationally related to the governmental proceeding, and in furtherance of the objective served by governmental consideration of the issue under review.
I don't know, like solving a murder? Oh my god, I'm gonna bash my head off the wall. Oh, this is why I get so mad. Oh, I get so mad. You don't understand. Maybe you do understand. That's what the takeaway is from this case. Okay, if you were gonna read it. What you're looking at is whether the intent to influence is manifest in statements that are closely and rationally related to the governmental proceeding and in furtherance of the objective served by governmental consideration of the issue under review. Okay? It is not cited for the proposition of whatever the hell this is. The statements are directed towards viewers and potential viewers of Kearney's live stream and readers of his blog, and their content does not seek to influence government action in any way. What? That's outrageous! This is a travesty! This is a shame! This is a mockery! I'm offended! My sense of juridical integrity is offended. That's, first of all, that is not what that case stands for. This is ridiculous. It's one thing if I were reading a motion with this language in it. This is a court decision. He's going to get overturned. This is going to be worse than Judge McCarthy's, she went on to be Judge McCarthy Naaman, but Judge McCarthy's decision in Cambridge v. Revolutionary Clinics v. 2. She got ripped apart at the appellate court, and it didn't matter that her brother was a judge on the appellate court at the time. How would I know? Because I have a special place in my heart for 94G31AI, and I won't let anyone tell me differently. Don't touch my statute. Don't do it. So anyway, my point is, he's going to get ripped apart. This is just... I'm a layman, although I did graduate law school. That is just wrong. That everything about that statement is wrong. Not only what the Lucy v. Kinnan citation, but then he backs it up. I want to be clear. He backs it up with, where do we get this from? Was that Lucy v. Kinnan still? I think it was. It was Lucy v. Kinnan cited in Blanchard. It was Lucy v. Kinnan. He's wrong! He's wrong, ladies and gentlemen. I am willing to stand on this hill and defend it like the Iranians with a Khorram Shahar guarding Shiraz. Listen to me. He's wrong. Lucy v. Kinnan contains basically the Blanchard analysis. Lucy v. Kinnan does not stand for the proposition that because you sent a post, it stands for the proposition primarily that what differentiates a private a communication intended to influence a governmental proceeding versus one that's not is whether it's public or private. That's the core. Blanchard is instructive in Lucy v. Kinnan. The court said it. Oh my God. Now I'm getting really confused. Like, what? Now I actually have concerns. Before, I just thought Judge Gilday was a little mad at the whole situation, which frankly, you get a little mad. Now I'm worried. Because that's just not right. That's just not... Neither Lucy v. Kinnan nor Blanchard, as enumerated and cited as instructive by the appellate court in Lucy v. Kinnan, stands for the proposition that a public blog post somehow is transmuted to equivalent in weight to a private email. Let's continue. I have to get to the end before I get really mad. Maybe he can redeem himself.
This intent to influence is manifested in statements that are closely and rationally related to the governmental proceeding, and in furtherance of the objective served by governmental consideration of the issue under review.
Which would make the operative analysis here whether Aidan was trying to petition the government to solve an unsolved crime, which wouldn't end with an acquittal. It would get more important if an acquittal happens, because that means nobody's been arrested who's actually responsible in the eyes of a jury.
This intent to influence is manifested in statements that are closely and rationally related to the governmental proceeding, and in furtherance of the objective served by governmental consideration of the issue under review, emphasis added, quotations and citations omitted. Id. Blanchard I thus established a limit on the words, in connection with, one that appropriately ties back to the language of the petition clause and the purpose of the anti-SLAPP statute. See id. Applying the above standards, we are quite confident that Kinnan's statement at issue did not constitute petitioning under the statute. True, Kinnan's initial statement in the exchange likely did constitute petitioning. That statement observed that the Malden City Council had scheduled a hearing on an important matter, right before summer break, and was critical of that decision. Kinnan's statement was also, at least arguably, directed to enlist in public participation at the hearing.
Hello! Hello! What this is going to go on to analyze, which is what it does stand for, is that derivative statements, unrelated to the initial petitioning, like a comment. Lucy v. Kinnan stands, in my opinion, I already see where this is going, for the proposition that if you make a post that says, like if you write a long blog post that says, I want to petition the government, or this case is like unsolved and this is who I think did it. If you want to do that, okay, that's petitioning, or go to this hearing, whatever. They're using a zoning hearing here, whatever you want. This developer's bad, this project's bad, whatever you want to say. That's petitioning. What's not petitioning is if someone in the comments is like, you're wrong, or I disagree with you, and then you say under it, in reply to them, a personal remark at an unrelated commentator. This case does not... Oh, I'm getting really mad. This is going to get overturned. Let me just tell you right now, that's just wrong. It's malicious to my soul. I'm not saying it was malicious by the judge, but it's malicious to my soul to interpret that case, the Kinnan case, to stand for the proposition that a public blog post and a YouTube analysis thereof is tantamount to either a private email to staff or a comment derivative of the original post but unrelated in the form of an attack to an unrelated third party, which is not what Aidan was doing. Jen McCabe wasn't in his comment section. He was not in the First Amendment complaint statements that were attributed. He was writing articles, neither of which, both in Blanchard and Kinnan, come up at all.
Kinnon's statement was also, at least arguably, directed to enlisting public participation at the hearing. GL circa 231, section 59H, 6 par.
Now, I'm not an appellate court judge. The appellate court might read it differently, but I'm telling you, it certainly doesn't stand for what Judge Gilday wants it to stand for, at a bare minimum.
The statement was made on a website dedicated to Malden politics, and thus likely had a sufficient nexus to influencing a government proceeding. See McDonald versus Patton, 57 Mass. App. Court 290, 295, 782 NE 2D 1089, 2003.
And this is 2025, the Kinnon case, so this is the most recent, probably, interpretation. I might need to look at that, but this is probably pretty good.
But the fact that Kinnon's
law.
initial post constituted petitioning activity did not then throw an anti-slap protective blanket over every post that followed. In
Okay,
contrast
so
to Kinnon's,
this is the takeaway, and Judge did not cite it for this. But if you want to cite to Kinnon as limiting the anti-slap law, this is the operative sentence, which is not what Judge cited.
But the fact that Kinnon's initial post constituted petitioning activity did not then throw an anti-slap protective blanket over every post that followed. In contrast to Kinnon's initial post, the post at issue does not meet the Blanchard eye test. Specifically, it contains no objective indicia that it was made to influence a government proceeding or to enlist public participation in same.
That is the only test that's operative for Kinnon, because it's actually Blanchard. Kinnon is just Blanchard in another form. Is there an objective indicia that it was made to influence a government proceeding or to enlist public participation in same? The Blanchard one that failed the anti-slap standard was a private email. The Kinnon one that failed the anti-slap standard, although Kinnon won anyway on summary judgment, was a reply in the comments. Neither of those are blog posts. Neither.
Specifically, it contains no objective indicia that it was made to influence a government proceeding or to enlist public participation in same. The post is certainly not directed to the government, nor does it mention any government proceeding or any of the issues related to the upcoming zoning hearing.
So what we're looking for is, under the actual standard, does Aidan's statements or posts, the larger post, is it directed at the government, or does it mention a governmental proceeding or any of the issues related to upcoming hearings? That's the standard out of Kinnon.
Rather, by the time of the post at issue, the third post in the chain, Lucy and Kinnon had veered off course. They were no longer seeking to influence a government proceeding, but instead throwing barbs at each other.
And notice, neither Kinnon nor the other guy in this proceeding, Lucy, that's his last name, are journalists. It doesn't matter. It doesn't matter. They get the same anti-slap analysis, and it's a strong protection, but it doesn't apply to derivative comments on the article or initial published statement, which is not what Aidan's statements were, and it doesn't apply to private emails to staff at a workplace, which is not what Aidan's blogs are. So, I'm sorry, Judge Gilday's 0 for 2 here.
Rather, by the time of the post at issue, the third post in the chain, Lucy and Kinnon had veered off course. They were no longer seeking to influence a government proceeding, but instead throwing barbs at each other. Kinnon
Okay, so
counters by
how...
arguing that insulting Lucy was part
Stop.
Rather,
Stop. How is it possible that this throwing barbs citation is applicable to Aidan talking about participants in the governmental proceeding? The throwing barbs thing is about some random commentator who jumps on the post, and then the initial guy who made the post fires back at him with an unrelated personal jab. How can this possibly be applicable to the people involved in the governmental proceeding? That would be like if a city councilor went into the comments and then Mr. Kinnon was commenting on the city councilor. Of course it would be directly related.
Kinnon counters by arguing that insulting Lucy was part.
We're back.
At oral argument, Kinnon's counsel posited that insulting your opponent was an accepted, even expected component of public discourse, employed to diminish the force of one's opponent's arguments. We are not persuaded, at least on the facts before us. Here, Kinnon's comment was directed at Lucy, and we cannot perceive any cognizable nexus to influencing government action. As in Blanchard I, 477 Mass. At 151 to 153, 75 NE 3D 21, the protections of the anti-slap statute will not extend to defamatory statements made outside of that context. And while Kinnon's insults do implicate Kinnon's free speech rights, and thus are protected from being sanctioned by the state. See Booz vs. Barry, 485 U.S. 312, 322, 108 S. Court. 1157, 99 L.Ed.2d 333, 1988, in public debate. An even outrageous speech such does not mean that Kinnon's statements are also entitled to protection as petitioning activity under the anti-SLAPP statute.
Okay. Oh, thank you to Midre Beach Care. 5 gift memberships. You are very kind. If your name is Sheila Duffy or MB Sensel or Indie Girl 7935 or Gen X Erica or Law and Disorder 101, you have just unlocked towel emojis from the very kind Madeira 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 Beach Care. God bless you. You're wonderful. Thank you so much. You all now have wonderful towel emojis, including Kofi the dog, who's Bunny Towel Mom's dog, Kofi. He knows me. He probably knows we're talking about him right now. He's looking right at the TV. He's like, well, what do? Do I have to, take an exam? Can I just continue to be a dog? Yes, Kofi, you can continue to be a dog. You're doing a great job. He's a dog. All right, let's continue.
The decision in McDonald, on which Kinnon relies, is not to the contrary. McDonald, 57 Mass. App. Court, at 293 to 295, 782 NE2D 1089. In McDonald, the plaintiff, a town selectman and retired police officer, brought a defamation action after the defendant characterized the plaintiff as acting like a Nazi. In McDonald, the plaintiff, the defendant's website, called Athonics Homepage, was designed as an interactive public forum covering issues related to Athol local government. This court held that the plaintiff's defamation claim was properly dismissed under the anti-SLAPP statute, noting the defendant's description of her website as technological version of a meeting of citizens on the town green.
Wait a minute! That's an even stronger argument for Aidan.
Although the website in McDonald and the Morgan Politics Facebook webpage contain similarities in their purported civic function, what this court held to be petitioning activity in McDonald is plainly distinguishable from Kinnon's post here. The post in McDonald was directed at a public official, criticizing him for official decisions related to his approval of a new police station and an ambulance service. In contrast, Kinnon's comment was an insult directed specifically at Lucy, another private citizen, and its content was divorced from Kinnon's original post.
Alright, we found our first just completely incorrect application of precedent. I'm sorry. That's a clear error of law. Just clear. And I'm not trying to be harsh here, okay? Look at that appellate court opinion and how it's written compared to this, okay? First of all. And second of all, this is a judge looking to, looking to justify a decision he made before he wrote the opinion. You know how I know that? Because he's forcing precedent to fit that is just not what he is purporting it to stand for. I'm sorry. It's ripe. People would appeal this either way, but this is ripe for appellate review. You got to have some of the other people who analyze these documents on YouTube look at it too. If we all come to the same conclusion, then yeah, he screwed up. Oh, Law and Disorder also started a membership parade. If your name is Nefarious Shenanigans, oh, that's a wonderful username, or Leslie Holland, or NH727, or Advidence 3780, or RN2 Bombs, that's great. We love our nurses, they're all wonderful. You just unlocked towel emojis thanks to the wonderful Law and Disorder. You all are starting membership parades all around the place today. You're all wonderful. You're all so kind. But yes, I must say, listen, I'm not being overly harsh here. I'm not saying, listen, this is a 50-50 call. I'm saying he got it wrong. Okay, I got to call, just like when people bomb people, civilians, and I get made. Okay, I got to call it like I see it. And I'm telling you right now that this Judge Gilday, got this wrong. This whole, operative section of the ruling is just wrong. That is not what Lucy v. Kinnon stands for. Okay, that is not what the Blanchard 1 decision, which is the operative nexus. How's that for operative nexus being used again in a different context? Syntactical, recursive, historical serendipity indeed. The operative nexus is Hammond. And Hammond's analysis is about the nature of the forum. Shout out Rome. Literally, not like an old PHP BB forum, but literally the forum that you make your speech in. So we've got to look at, like, the test that I'm constructing here that I think is the relevant, applicable appellate principle that's binding is, 1, what's the forum? Are you sending a private email or, like, publishing something on, like, the internet? 2, or in a newspaper. 2, what is the purpose of the forum? Is the forum, like, where people gather, like akin to a digital town square, and read things and talk? Then yeah. Okay? That probably meets the Hammond and Kinnan test. And then the real operative standard, which Judge doesn't even pull out of Kinnan, is, was the intent of the speaker to influence a governmental proceeding? And then if you really want to stretch it, were there any remarks that were derivative of the statements aimed at public figures, right? Not a private commentator. Were there any derivative remarks that were unrelated to the initial coverage? Like sparring with them in the comments. And by the way, that only applies if they're private citizens. If you're talking about public figures as part of a governmental proceeding, neither Kinnan nor Hammond 1 would bar that discussion as long as there's a nexus to a governmental proceeding, which, if they're involved in said proceedings, is per se. So this is just, the whole analysis is wrong. No wonder he got overturned before, Judge Gilday. It's just wrong. It's ham-fisted. First of all, it's making me upset, because I don't like when people play loose and fast. When I dig into a case, if a lawyer does it, I get really mad. If a judge does it, I've never run into it before. You can't do that kind of thing. You're going to get it has to be appealed. I'm sorry. That's my lay opinion. It must be appealed. We're not even at the part about Karen yet. We're only 1/3 of the way through this damn thing. Oh, God. All right, let's continue. So I just tore that apart. All right, I don't need to look at, what was the other case here? Just in case, I have Global Naps v. Verizon New England Inc. I think he cites to that too. I don't even need to look at that, because I understand, like, what this is trying to make. And then, actually, I guess we do have to look at it, because so it's a two-pronged analysis here on page 5 into page 6. The first prong of Judge's analysis is based on this misapplication of Hammond 1 and Lucy v. Kinnan about the nature of the forum that the comments are made on. Then there's a substantive analysis and finding that Kearney's statements concern a topic that has attracted government attention, but that in and of itself does not give them the character contemplated by the statute. So now we have to look at Global Naps v. Verizon, and let me just make sure this is from 2005. No, we don't need Twitter. That's correct. We will do our war stream later, though. I do have it ready to go if anything happens. Yes, that's 2005. Let's take a listen. And this is what you have to do in order to read through a decision. You don't take anyone at their word just because they say it doesn't mean that's what the decision
Global Naps,
says.
Inc. versus Verizon New England, Inc. Full name, GLOBAL Naps, Inc. versus Verizon New England, Inc. Present, Greenberg, Lawrence, and Cohen, J.J. Anti-SLAPP, Statute. Constitutional law, right to petition government. Statute, construction. In an action brought against a telecommunications provider, defendant, alleging defamation and trade disparagement arising from a statement made by the defendant's employee to a newspaper reporter, the judge properly denied the defendant's special motion to dismiss, brought pursuant to GL Circa 231. S59H, the anti-SLAPP dismiss was heard by Margaret R. Hinkle, J.
Hello, we're back.
Joseph D. Steinfeld, David E. Plotkin with him, for the defendant.
Let me just restart
Jeffrey
that one
C.
more
Mellick
time.
for the plaintiff.
Sorry.
S59A. In an action brought against a telecommunications provider, defendant, alleging defamation and trade disparagement arising from a statement made by the defendant's employee to a newspaper reporter, the judge properly denied the defendant's special motion to dismiss, brought pursuant to GL Circa 231. S59H, the anti-SLAPP statute, where the defendant failed to demonstrate that the statement in question, which was a tangential statement intended, at most, to influence public opinion in a general way unrelated to governmental involvement, was made in connection with a matter under review by the Department of Telecommunications and Energy and thus constituted protected petitioning activity as defined by the statute.
This is what we want.
603 to 607. Civil action commenced in the Superior Court Department. Greenberg, J. At the center of this action is a clash between telecommunications providers, both of which are regulated by the Federal Communications Commission under the Telecommunications Act of 1996, 47 U.S.C. Sections 251 A Secu. 2000. Pursuant to 47 U.S.C. Section 252, B.1, the plaintiff, Global Naps, Inc. Global, brought 2 arbitration actions against the defendant, Verizon New England, Verizon, which were resolved. Page 601. In Verizon's favor in 2002. Subsequent to those decisions, one of which had already been appealed, Jack Conroy, Verizon's regulatory affairs chief, gave an interview to a Boston Globe business reporter, who quoted Conroy as having said that the arbitrator's decision essentially shut down a scam that Global very cleverly had developed in the late 1990s. As a result, Global brought the instant action against Verizon for defamation and trade disparagement. Verizon's special motion to dismiss pursuant to GL Circa 231, Section 59H, the Anti-SLAPP, Note 2, statute, was denied by a Superior Court judge, and Verizon appeals. Note 3. 1. Background. At issue is whether GL Circa 231, Section 59H, protects Verizon from liability for the disparaging statement Conroy made during the course of his interview with the Boston Globe reporter. In particular, Verizon contends that Conroy's comment satisfies the statutory definition of petitioning activity. It contends that Conroy's statement was made in connection with Global's pending appeal of the arbitrator's decision. We conclude that the statement does not fall within the ambit of the statute's protection because it was merely an oblique reference to Verizon's petitioning activity and was not a protected instance of full participation. And robust discussion of issues before a governmental body, Duracraft Corp. versus Holmes Prod. Corp. 427 Mass.
So the standard
156,161, 1998, quoting from the preamble to 1994 House Doc.
Wait, so the standard here is whether this is an instance by Aidan of full participation in robust discussion of issues before a governmental body, and he cites it as this Aidan's are statements that concern a topic that has attracted government attention, but it does not give them the character contemplated by the statute. All right, let's. I don't know, Judge Gilday. It's not looking good for you now.
To place the issue in context, we summarize the undisputed facts from the pleadings and affidavits contained in the record that both parties compiled for this appeal. The statement upon which Global bases its defamation claim was made within the context of a larger business dispute. Global and Verizon provide telecommunications services in Massachusetts. The two companies are competitors regulated by the Telecommunications Act of 1996 Act. Verizon, among other things, is page 602. An incumbent local exchange carrier, ILEC, which means that it provided telephone exchange service in Massachusetts prior to the passage of the 1996 Act. Global is a competitive local exchange carrier, CLEC, meaning that it began providing service after the 1996 Act required ILECs to allow CLECs to connect to their telecommunications networks and to enter into interconnection agreements that specify the terms of use and payments for service between companies.
Oh.
Global's business is routing, dial-up, telephone calls from end users' computers to internet service providers, ISPs. As competitors in a regulated industry, the two companies are frequently, if not constantly, involved in proceedings before courts and other governmental entities. One feature of the 1996 Act is a provision for binding arbitration by state commissions when ILECs and CLECs cannot agree on the terms of an interconnection agreement. In Massachusetts, such arbitration is before the Department of Telecommunications and Energy, DTE. 47 U.S.C. Section 252, B.1. The two arbitration actions against Verizon were decided by the DTE in Verizon's favor on December 12, 2002, and December 20, 2002. Both arbitrations were related to Global's provision of virtual exchanges to ISPs. A virtual exchange allows dial-up internet users to dial what appears to be a local telephone number to connect to ISPs whose physical equipment is at Global's Quincy premises, regardless of whether the dial-up customer ordinarily can make local calls to Quincy. Global and Verizon disagreed whether such calls should be treated as local in their interconnection agreement. If deemed local under the 1996 Act, Verizon would be responsible for toll-free transmission of its customers' local calls all the way to Quincy. And Verizon would also have to pay Global for each call by one of its customers to Global's virtual, local, exchange. If the calls were not treated as local, Global would pay the cost of transmission to Quincy and would not be entitled to payment for receiving calls from Verizon customers. In the first ruling, the DTE determined that the company should not treat Global's use of virtual exchanges as local calls. In page 603. The second ruling, the DTE determined that the interconnection agreement between the companies did not require reciprocal payments to Global for ISP-bound calls from Verizon customers.
Pause. I just wanted to say thank you to the wonderful In Limonene, absolutely the best in the world. If your name is, they just started a wonderful membership parade. If your name is Thomas, or Lost and Stuck in Detroit, or Jody Callahan, or Jenny Lulu, or Kyle Sharkey, Kyle's going to lose his mind. He's getting ready for the FOIA drops today. That's why we have to get done by like 4:15. Listen, I know the man at the Norfolk County District Attorney's Office is sitting there at his computer watching this damn stream, and he's looking at the other computer, and he's uploading the FOIA documents. I see you, man. I know you're right there with Brandon Hunt, whatever your name is. I know what you're doing, sir. Don't look at me like that. Don't you dare. I know what you're up to. Anyway, hi, Kyle Sharkey. You're a towel. Let's continue.
The second ruling, the DTE determined that the interconnection agreement between the companies did not require reciprocal payments to Global for ISP-bound calls from Verizon customers. Global appealed the December 12, 2002, ruling before the comments that gave rise to its defamation claim were made. On January 3, 2003, the Boston Globe printed an article about the arbitration rulings. How firms come up empty versus Verizon in rulings, Boston Globe, January 3, 2003, at E3. The article stated that in a pair of rulings, the DTE determined that Internet traffic originated by Verizon customers does not consist of local calls that require Verizon to make so-called reciprocal compensation payments to carriers such as Quincy-based Global Naps, IBID. It said that the rulings closed what Verizon called a loophole, forcing it to pick up the cost of carrying Internet traffic from throughout eastern Massachusetts to Global Naps data center in Quincy, IBID. The article then summarized and quoted a conversation between the reporter and Conroy, which became the focus of Global's defamation claim. Jack Conroy, Verizon's Massachusetts Regulatory Affairs chief, said the DTE ruling shut down a scam he said Global Naps very cleverly developed in the late 1990s. Using so-called virtual phone numbers throughout the state that did not require Global to install any switching equipment, Conroy said. Global got Verizon to pay for most of the cost of handling calls to its internet service provider customers while claiming Verizon owed it additional reciprocal compensation payments as well. Analysis. The burden is on Verizon as the moving party to make a threshold showing that the activity at issue is petitioning activity within the purview of the anti-SLAPP statute. Fabra vs. Walton, 436 Mass. 517,522, 2002. In support of its motion, Verizon furnished affidavits and pleadings to the motion judge indicating that Conroy's comment was made in connection with a matter under review by the DTE and the courts, and page 604. Thus, constituted. Petitioning activity, as defined by the anti-SLAPP statute. The judge rejected this contention. Note 4. Relying on a broad reading of the statutory definition of a party's exercise of its right to petition, Verizon argues that the motion judge's determination was incorrect. The statute states that a party's exercise of its right of petition shall mean 1. Any written or oral statement. GL Circa 231, Section 59H. Verizon focuses on the second phrase in the definition, arguing that Conroy's statement was made in connection with the appealed DTE ruling and was therefore protected by the statute. Under this view, any statement about an issue under some form of government consideration, whether defamatory or not, would be protected by the statute. We read the phrase, in connection with, more narrowly. The statute enumerates no fewer than 5 types of statements. Page 605. That comprise petitioning. Verizon focuses exclusively on the second category and asks us to read it broadly and in isolation. Paying attention to the context compels the conclusion that the sweep of "in connection with" is limited because the phrase pertains to statements made to influence, inform, or at the very least, or reading, in connection with, as embodying, to some extent, similar purposive elements. Note 5. Additionally, Verizon fails to acknowledge that the first sentence of GL Circa 231, Section 59H, refers to parties' exercise of its right of petition under the Constitution of the United States or of the Commonwealth. See Plant vs. Wiley, Ante 151. 156 N.6, 2005. That a statement concerns a topic that has attracted governmental attention, in itself, does not give that statement the character contemplated by the statute.
Okay.
Our conclusion in this case is supported by 3 recent decisions: Coburn vs. Gasfriend, 327, 2005, Note 6, Plant vs. Wiley, Supra, Note 7, and Wynn vs. Craigle, Ante 246, 2005. All 3 of these decisions emphasize the language set forth in the first sentence of GL Circa 231, Section 59H, i.e. that claims sought to be dismissed pursuant to a special motion must be based on said party's exercise of its right to petition under the Constitution of the United States or of the Commonwealth. As the Supreme Judicial Court stated in Coburn v. Gasfriend, Supra at 333, the right of petition contemplated by the legislature is thus one in which a party seeks some redress from the government. In the instant case, the tangential comment is not one that is related to the petitioning process. The recent case bearing most directly on the issues here is Wynne v. Craigle, Supra. In Wynne, a former firefighter brought suit against the widow of a deceased firefighter on the basis that she had defamed the plaintiff in the course of a fire department investigation. The plaintiff alleged that both a written statement to the Greenfield Fire Department and articles in the Greenfield newspaper contained defamatory statements by the defendant about the plaintiff. Sometime after her husband's death, which was a suicide and which the defendant maintained was precipitated by the plaintiff's harassment of her husband, the defendant pursued legislative benefits as the widow of a deceased firefighter. See Wynne v. Craigle, Supra at 248 and N.3. At oral argument, the plaintiff apparently conceded that the written statement to the Greenfield Fire Department made during the course of an investigation came within the ambit of the anti-SLAPP statute. Therefore, this court only had for its consideration the question whether the statements to the newspaper reporter were entitled to anti-SLAPP protection. The court reasoned that the statements to the Greenfield newspaper were essentially mirror images of those she made during and in connection with the departmental investigation of the plaintiff. Taken in context, a mere repetition of those statements to the media was also possessed of the characteristics of petitioning activity. Wynne. Additionally, the court concluded that the defendant's statements were sufficiently tied to and in advancement of her petition for benefits as the widow of a firefighter. 2. Fall within the ambit of statements made in connection with legislative proceedings within the meaning of GL circa 231, section 59H, and constitute protected petitioning activity on that basis as well. An examination of the materials supporting Verizon's motion does not indicate that Conroy's disparaging comment concerning Global's position before the DTE had the potential or intent to redress a grievance, or directly or indirectly to influence, inform, or bring about governmental consideration of the issue. Because it lacks the crucial characteristic, the case law suggests it should not be deemed petitioning protected by the statute.
Why?
Unlike the statements to the reporter that were found to be protected in Wynne, the statements here were not mirror images, but what was said in a governmental forum.
Wait a minute! Aidan's... Wait a minute! Wait a minute! Wait a minute! Aidan's articles were reprinted verbatim and put up in the federal grand jury. It's per se a mirror image of what was said, because his articles were put up. Oh, wow. So Wynne is really controlling here. These aren't tangential, unrelated comments. They were the federal investigation in part. Oh, wow.
Instead, the comments were incidental observations that were not tied to the petitioning activity in a direct
Hi,
way.
tiny full house.
See McClellan versus Jokish, 431 Mass. 343,348 N.7, 2000, special motion to dismiss should not be allowed, merely because there is ongoing litigation between the parties in a different forum. 113, 122 to 123, 2002, communications with officials from the Federal Deposit Insurance Corporation and efforts to spur others to contact elected officials by unit owners of a condominium opposing plaintiff's purchase of units fall within the definition of petitioning activity protected by the statute. From the language of Section 59H, its context that we have described, and its treatment in other Massachusetts decisions, it appears that the insulation with which the statute covers statements made before a public body, statements made to further a citizen's efforts to gain governmental relief, or statements made to enlist public participation to effect favorable consideration of an issue by a public body, does not protect tangential statements intended, at most, to influence public opinion in a general way unrelated to governmental involvement.
The standard there is actually that. And also the mirror image standard. Wrong again. I knew it. Absolutely not. It's the mirror... Oh, God. This is very ripe for appeal. I'm telling you, Aidan's statements they are per se, especially if anyone can prove, although I don't have any grand jury records, but they've been talked about in various articles. If anyone can prove that some of the statements that are in the First Amendment complaint were put up at the grand jury federally, that is mirror image. Oh, God. All right, let's move on. I ripped that one apart. Now let's see where we go with the next one. Apparently, I'm an efficient little towel. Thank you for supporting Towel News. I got to get through this motion, though, because I got to pause. I got to, hang out with Towel Girlfriend for a few minutes before she goes to bed. Then I got to see bombs start falling because the stock market's about to close. So we got to keep going. Now we got to go back to this
To
one,
influence
so
public-
pardon me.
Commonwealth of Massachusetts.
All right, so now where are we? We're at finally, Kearney relies heavily on the argument. Okay, where's finally? I don't have time to tear the next one apart. I tore that
Finally,
apart.
Kearney
though.
relies heavily on his argument that his statements were reasonably likely to enlist public participation in an effort to effect consideration by an executive or judicial body. In his motion, he cites multiple instances where he both encouraged people to
Typo!
demand answers from the Massachusetts State Police and
Typo!
Norfolk District.
Typo! I found a typo! Typo! I found a typo. Look at it! Look at it! He cites multiples instances. Typo! Typo alert. I found a typo. I found a typo. In his motion, he cites multiples instances. Typo. That's it. Throw the whole thing out. Typo alert. I found a typo. I won't stand for it. I also need to find where footnote 4 was made. Hold, please. Where is footnote 4? Ah, okay. So, after the second trial had ended, let me just read footnote 4 before we move on. The point is, I found a typo. Typo! Typo alert. I found a typo. Throw the whole thing out.
4. To the extent Kearney contends that his post-verdict statements were likely to encourage review by law enforcement into those responsible for O'Keefe's death, allegations in the fact belie his claim. For instance, the FAC cites Kearney's communication to his followers to use code for the McAlberts killed John O'Keefe. FAC. At para. 141. It strains credulity to argue that such a statement, which obscures the message so only his followers can understand it, could reasonably be interpreted as made to influence, inform, or reach government bodies. The FAC also alleges that Kearney
Wait, what if he knows his followers are part of government bodies? Oh God, that's the whole point.
FAC also alleges that Kearney posted a video encouraging his followers to attend and protest a fundraiser hosted by a supporter of the plaintiffs, asserting that it was being held for the people that framed Karen Reed for murder, and that they killed John O'Keefe. FAC at para. 133. It is unclear how encouraging his followers to attend a private event would be reasonably likely to encourage review of O'Keefe's death by an executive body.
Everyone now understanding why Kate Peter advertised that ahead of time? So that Aidan would encourage people to go, and then that could be used against him. Look who won the pony. Almost a little too smart for their own good. That's why I called the Colin Albert allegate where Kate Peter leaked the fake story about Colin Albert selling drugs a modified limited hangout, because I bet Kate knew, my opinion, that there was a video of John O'Keefe observing a drug deal, which means, you know what I'm saying. But anyway, don't take the bait. The bait is multi-layered. Like, clearly, she's not an attorney, but there are attorneys that are laying some of this bait. That's very high-level bait. And by the way, don't test me right now, please. Just don't. I'm not in the mood. I got other stuff going on. I got real, honest-to-God problems in the world. And although Karen Reed and Aidan Kearney and what they're fighting are on my radar, I'm not talking about anyone in their movements. People who are trying to take them down, don't test me right now. Just don't. Just don't. Go about your life. Smile. Be happy. Do not test me. Not right now. I'm not in the mood. I'll call the Pope. I'll do it. Don't make me call the Pope. Listen, the last time I got mad and started yelling for the Pope, he sent the nuncio to southern Lebanon as the bombs were falling. Don't make me get all mad. But yeah, that's a general message. Now is not the day to test me. So anyway, yeah, it was bait. It was clearly bait. I mean, so I'm not saying, listen, it's high-level bait, but you got, all of you, general advice, you got to look out for the bait. They lay bait to use it against you, and it's easier to use it against you civilly than criminally. So always be on the lookout for the bait, and get rid of the moles. Do good background checks. Have good OPSEC. If you're a high-value target, run virtual machines. Do not open links, okay? Do not share your passwords. Buy new devices. Have two-factor authentication enabled on everything. Alright, these people move brutally, ruthlessly, and they don't apologize. They ask for forgiveness and not permission. Alright, let's go to in his motion.
judicial body. In his motion, he cites multiple instances where he both encouraged people to demand answers from the Massachusetts State Police and Norfolk District Attorney's Office and encouraged his audience to engage in standouts and to gather at the courthouse in protest of the prosecution. While the court agrees with Kearney that such conduct constitutes petitioning, for to the extent Kearney contends that his post-verdict statements were likely to encourage review by law enforcement into those responsible for oak activity, his argument that the statements cited in the FAQ are related to this conduct and therefore should be viewed similarly as without merit. See Lucy, 106 Mass. Court, at 364. Fact that defendant's initial post-constituted petitioning activity did not then throw an anti-slap protective blanket over every post that followed.
About an unrelated third party in the comments.
The defamation claim is not aimed at the specific instances that Kearney cites in his motion. Rather, the claim encompasses statements that are far removed from any call to the public to appeal to the government, namely, the many instances where Kearney accused the plaintiffs of murdering O'Keefe and covering up their crime by addressing him directly at their homes, via his livestream, or in the case of McCabe, at her daughter's lacrosse game. In those statements, Kearney neither explicitly nor implicitly calls on his audience to implore anything to a governmental body, degree.
Okay, pause. Law and Disorder has just launched a very large membership parade, so if your name is I Love Dogs 1970, Attorney O'Leary, oh that's wonderful, Tiny Full House, excellent time to come in, Miss Cakes 1198, or Jules 86617, or Hippie Chick, that's wonderful, or Jason Snyder, or Bob Cromwell, or China Set, you have just unlocked Super Towel emojis, you're wonderful. Oh, Willow, that is so kind of you. God bless you, Willow. Well, you all are so kind. Willow says, you're highly intelligent, Grant, and I look forward to listening to your analysis. Well, Willow, you are highly compassionate. God bless you. Enjoy your towel wrench, and thank you so much for your support of Towel Channel. Oh, please. Oh, you're also wonderful. I'm so grateful you're able to use your emojis. I just wanted your chat to catch up, so if you just heard your name read, you click on the little emoji icon, right? Oh, Squirrel, you're so wonderful. I don't even get... Oh, God bless you, Squirrel, and anyone who has sent donations. I try to go through them all at once sometimes after stream because my damn phone doesn't send the notifications, but I just looked down. God bless you, Squirrel. And thank you so much for being you. You're wonderful. Squirrel's one of my favorite. Every time I see Squirrel's name pop up in a chat, I'm like, oh, that's Squirrel. Hi, Squirrel. Sometimes I watch other channels. I see Squirrel, and I'm like, hi, Squirrel. You're a tail. I see a lot of you around. Sometimes I'll just go watch another stream. I'll see some of you. Be like, hello. I say hi. You all, there's like 100 of you who say hi. It's great. But my point is, God bless you all. Thank you for your support of Towel Channel. I feel very loved and supported. However, I just want to be clear that we're comparing apples to oranges here with Mr. First of all, I know Mr. Kinnan. Mr. Kinnan, first of all, he won on summary judgment. Second of all, Mr. Kinnan was replying to a comment by somebody else who was not a subject, like, of the post, okay? And Judge is comparing that to Aidan's statements about the people who were witnesses in this case. Okay, it's fundamentally flawed reasoning.
To be sure, the fact cites many statements that were reasonably likely to enlist Kearney's audience to share his opinion and to make that opinion known to the plaintiffs and other members of the public. See, e.g., FAQ at para 90, citing Kearney's statements that he has nothing but hatred to Plaintiff McCabe, as I should because I'm normal. I'm a rational person. Any rational person hates Jennifer McCabe, and is disgusted by her because Jennifer McCabe is a pig. She's a pig. She's a cop-killing pig. FAQ at 100.
British Reporter Towel! Listen! British Reporter Towel, I don't know if I can allow those words under the standing order of the House. Listening to British Reporter Towel say that. Judge Gilday wrote that, okay? I didn't write that. I'm just reviewing the court. British Reporter Towel's like, I don't know if I want to say this. British Reporter Towel's having a night. Listen. Do you all get the sense that maybe, just maybe, Judge Gilday doesn't like Aidan Kearney? You think maybe, just maybe, there's a little bias here, a little prejudice? I'm just saying. Like, he's kind of like harping on, you know, the worst of the worst. You know, Judge Doolin would probably write, and I'm being fair, all right? I read a lot of opinions, as you can tell. Like, you write an opinion, I'm going to rip that thing apart. So I've read everything you can imagine, because when you write an opinion, I read all the decisions. Like, not, like, when you all see me read decisions on stream, I'm normally trying to get through them. But this is what it's like when I read a decision just, like, for my leisure. I read every citation, and then I read every citation in the citation. And then before I know it, it's like 1840, and I'm, like, learning about some obscure, like, company that does not exist anymore, and then I'm researching their building, and I'm looking up the, like, architecture and the development of the land plot and their corporate records. I go really in depth. Then I go to the library. Oh, we have I have the greatest discussions with librarians. Oh, wait till you hear about the time I called the FBI about the Saudi spying on our domestic ballistic missile interceptor technology. The FBI man at the very high-ranking part of the FBI was like, "How did you find this, sir?" And I was like, "Oh, I'm a journalist. I was just looking into the father-in-law of a juror in the Karen Reed case." And he was like, "Oh." And then we just kept going in our conversation. That was the only call with the FBI I've ever had where it ended. As soon as he put together what I was saying and how serious it was, it's very complicated. It involves like a Saudi intel agent in the 1980s and this patent on echolocation on a system that would go on to become the Raytheon Boeing Warrior X, which is like a shoulder-mounted missile interception technology that uses like a corollary to natural language processing, but in the audio spectrum, like the acoustic spectrum, in order to detect missile launch positions and then tell our soldiers how to hide from them. Anyway, the point is, in the 80s, there was a fake patent that was used to develop these technologies. One man was Egyptian. You know him as Paula Prado's father-in-law, who stole our missile interception technology and did bad things with kids in Attleboro and somehow got an 18-month concurrent sentence where Kevin Reddington was his lawyer. Anyway, that was wild. But the point is, so I'm looking into this patent and I find this Egyptian man on the patent. Then I found this Saudi man on the patent, and I traced him down to King Fayed Petroleum University, but his middle initial was different. So I told this all to the nice FBI man, and he was like, "Oh my God, I have to make a call," and then he hung up on me. It was the craziest thing I've ever. I hope they protected our soldiers. I just didn't know how to react to that situation. I think he was a little baffled, but I was like, "You don't understand. I just look into things, and then I find things, and I get concerned. I don't want our soldiers to get attacked because in short, if you know how to pre-program the list of MD5 hashes in ballistic missile interceptor technology, then you can create an acoustic spectrum launch sound that won't be detectable. You understand? You understand? It's a battle of the algorithms." So anyway, my point is, this is what it's like when I read a decision on my own. I tear it apart, and I'm sorry to have to bring you through it, but I think a lot of you find it interesting, so more power to you. Anyway, British reporter tell, he kind of he needed a break. He had some tea. He's taken a breath. He's going to be back with us. That was a really intense sentence for him to read. Yeah, I just want to tell you, okay?
Jennifer McCabe has to cover her face in public like this because everywhere she goes people immediately see her face and recognize her as a cop killer is a great thing. Faka para. 140.
Oh, I was saying
Five,
Judge Gilday is a little
Kearney
biased.
does not explain how his enlistment of 200 individuals to participate in Rolling Rally 2.
Wait, what? Can we start that again? Why is having the rolling rally not petitioning the government?
5. For instance, Kearney does not explain how his enlistment of 200 individuals to participate in Rolling Rally 2. Go at the plaintiffs' homes while he, shout, Ed, into a bullhorn that Brian Albert and McCabe were covering up John O'Keefe's murder.
Because the murder is unsolved? Hold on. Who has been convicted for John O'Keefe's murder? Does Judge Gilday not want to say the words, "the crime is unsolved"? I mean, that's kind of what the petitioning is about.
O'Keefe's murder, see FAC at 60, was reasonably likely to enlist public participation in an effort to effect. Consideration by an executive or judicial body.
That is not the only standard, as we know. It's actually, if we go into the cases that we just reviewed, especially the Kinnan case citing Hammond 1, That is not the standard at all. It is way more broad than that, and that's a 2025 case.
Consideration by an executive or judicial body, nor does he address how going to McCabe's daughter's lacrosse game and calling her cop killer was likely to do so. See FAC at para. 59. See Iasley versus Armstrong, 56 Mass. App. Court 740, 748 to 749, 2002, although neighbors' opposition to home renovation before town boards was protected, a threat made as the neighbors were leaving a hearing before the board was not protected. Simply, filming his actions and posting him later does not bring such conduct under the...
He summarizes that as although neighbors' opposition to home renovation before town board was protected, a threat made as the neighbors were leaving a hearing before the board was not protected.
Filming his actions and posting him later does not bring such conduct under the protections of the anti-SLAPP.
The analysis is not just did he film it, it's was he trying to raise public awareness to influence the outcome of a judicial proceeding, because he was saying the government had done
Filming
something
his
wrong.
actions and posting him later does not bring such conduct under the protections of the anti-SLAPP
That's not right.
statute.
I disagree.
Alleging Kearney addressed his audience members who had not confronted the plaintiff, stating, "Hey, right fucking they're walking around like nothing happened. What are you going to do about it, huh? You gonna ask them anything? You gonna talk to them? ... You're not in this for being uncomfortable, or making, people who committed horrific crimes uncomfortable. However, for such statements to be protected petitioning activity, they must be reasonably likely to enlist public participation in an effort to effect, bring about, governmental consideration of an issue, emphasis added. See Doe versus Thurl, 106 Mass. App. Court 532, 538, 2026. The statements that are the subject of the defamation claim clearly are not. See Global Naps, Inc., 63 Mass. App. Court.
What? The whole point was the federal
Commonwealth of
government started to look into this. And we're looking into this. Listen, this is really weird. Okay? This is really weird. There's something really off about this decision.
The statements that are the subject of the defamation claim clearly are not. See Global Naps, Inc., 63 Mass.
We read Global App.
Court, at 607, anti-SLAPP law, does not protect tangential statements intended, at most, to influence public opinion in a general way unrelated to government involvement.
It's like Judge Gilday is pretending the federal government does not exist for the purpose of this investigation.
See also Cadle Company versus Schlickman.
Oh, thank you,
448
Jeannie
Mass.
Lynn. Great Uncle Alert.
242, 250 to 252, 2007.
You're so
Website
kind.
designed to disseminate to the public information about plaintiff to attract clients to. Defendant's law practice was not reasonably likely to enlist public participation in an effort to affect such consideration. 2. Other claims. Kearney's motion as to the plaintiff's other claims for intentional and negligent infliction of emotional distress, civil conspiracy, and Chapter 93A similarly fails because the claims are clearly not based solely on petitioning activity. These claims go beyond Kearney's statements. Calling the plaintiffs murderers, which as explained above are themselves primarily not petitioning activity, and seek redress for his actions in purportedly organizing the rolling rally mentioned above, publicly releasing the plaintiff's personal identifying information, harassing the plaintiffs and their family members and encouraging others to do the same, conspiring with Reed to cover up her crime by wrongfully accusing the plaintiffs, and operating a commercial enterprise selling merchandise featuring the plaintiff's names and likeness. As to these claims, Kearney also has clearly not satisfied his initial burden, and therefore the motion must be denied. B.
What?
Petitioning in one's own right.
Where's
Even
the
if
reasoning?
Kearney's conduct that is the subject of the challenged claims could be
He doesn't
considered
even
petitioning
provide any
activity,
reasoning
his
for
motion
that.
fails for an additional reason.
He doesn't even provide any reasoning for that.
Considered petitioning act.
I forgot I have a hard stop at 4 p.m. Eastern for a doctor's appointment, so I gotta hurry.
The anti-SLAPP statute provides that a special motion may be brought for claims against a party that are based on said party's exercise of its right of petition under the Constitution, GL circa 231, section 59H. That phrase is read as restricting the statute's coverage to those defendants who petition the government on their own behalf, emphasis added. Coburn vs. Gastfriend, 443 Mass. 327, 332, 2005. The statute is designed to protect overtures to the government by parties petitioning in their status as citizens. Id. Although the party bringing the special motion need not be the beneficiary of The particular course the party seeks to advance, protections of the statute are limited to those who engage in petitioning activity in their own right. H.A.M. Risk, LLC versus Voigtland, 476.
That
Yes.
reasoning is weak on its own face. They don't have to be the beneficiary, and I'm sure if we
Here,
read that
the fact
case,
alleges
I'd be
that Kearney
mad.
was not speaking on his own behalf, but rather on behalf of Reed.
And behalf on the public, who don't know who,
The
as
fact
at this
alleges
point, actually murdered John O'Keefe.
The fact alleges that Reed found and enlisted Kearney to publicize a story about the plaintiffs and that Kearney agreed to and did publicize and widely disseminate Reed's false claims about the plaintiffs and others in an effort to destroy the reputations of these individuals, so that Reed could evade responsibility for causing the death of O'Keefe. Fac at Paris. 22 and 25. It further alleges that Kearney acted on behalf of Reed in publishing defamatory statements about the plaintiffs to assist Reed in her trial, and that Kearney used information in his blog posts which read, funneled, to him, with knowledge that he would publish it on her behalf. Fac at Paris. 25 and 34. In stark contrast to the allegations in the FAC, Kearney characterizes his statements as an effort to raise awareness about police corruption, which he contends is his long-standing cause. He argues that much like the defendants in H.A.M. Risk, LLC, he was petitioning on his own behalf as an activist and a citizen. In that case, the SJC...
Breaking. I am told that the Boston Magazine article regarding the Karen Reed case by Gretchen Voss has been updated again, this time regarding a message by attorney David Yannetti. You never want to see a newspaper article or magazine article with one correction. It now has two. My pleasure,
On behalf as an
Moonbeam.
activist and a
Hi,
citizen.
Francine.
In that case, the SJC concluded that environmentalists sued for defamation based on statements made in the Huffington Post criticizing a scientific consulting firm that purportedly defended polluters were engaging in petitioning activity. BJE calls they expressed their own opinions, were speaking for themselves and at their own behest. JD 476 Mass. At 488 to 489. Kearney's comparison to the defendants in H.A.M. Risk, LLC misses the mark. The statements that are the subject of the plaintiff's claims in this case have nothing to do with police corruption. The fact does not seek to hold Kearney liable for accusing public officials of a corrupt failure to investigate the plaintiffs for the killing of Officer John O'Keefe. As Kearney contends, see Kearney's reply at 4. Rather, it cites Kearney's repeated accusations that the plaintiffs are cop killer, and murderers who lied about what happened with O'Keefe. See, e.g., Fac at Paris. 59, 95, 101, 109, 110, 114. Given the content of the statements, it is more than a stretch to conclude that they were in furtherance of advancing Kearney's stated cause. Moreover, while Kearney's affidavit states that he wrote his blog posts on his own and Reed did not funnel him information, it does not refute the allegations that Reed enlisted Kearney to publicize her story and that he did so to assist in her trial. Thus, unlike the defendants in H.A.M. Risk, LLC, Kearney has not shown that he was speaking for himself and at his own behest. While the anti-SLAPP statute provides very broad protection for petitioning activities, it was intended to protect the right to petition the government for the redress of grievances. 10. Guaranteed by the United States Constitution. Duracraft Corp. 427 Mass. At 161. Where there is no reasonable basis to conclude that Kearney's statements and conduct at issue in the plaintiff's claims were in an effort to petition to the government for redress of harm, Kearney has not carried his threshold burden. 2. Defendant Reed's initial burden. The plaintiffs assert claims against Reed for defamation, intentional and negligent infliction of emotional distress, for aiding and abetting in Kearney's defamation and infliction of emotional distress, and civil conspiracy. Reed has failed to show that the claims are based solely on her exercise of the right to petition and have no other substantial basis. Degree. Copyright. The plaintiffs filed the FAQ on June 5, 2026. Reed served her motion to dismiss on June 23, 2026. For reasons unknown to the court, Reed's motion fails to address any newly added allegations in the FAQ. Reed has attempted to use a reply memorandum to respond to the argument in the plaintiff's opposition that she neglected to account for Many statements in the FAC, however, under Superior Court Rule 9A(a)(3), a reply memorandum is limited to matters raised in the opposition that were not and could not reasonably have been anticipated and addressed in the moving party's initial memorandum, emphasis added. Reed clearly should have anticipated that the opposition would have addressed the neglected factual allegations. Nevertheless, the court has considered her argument in the reply brief and finds it unpersuasive.
I mean, talk about indicia of judicial bias. Come on! Reed should have known that the opposition was going to supplement their pleading to add new facts. Excuse me? And we can already see Judge Gilday's going to dispatch of this very quickly.
Reed's motion cites a handful of allegedly false statements she made about the plaintiffs, which she contends form the basis of the defamation claim and fall under all 5 categories of petitioning activity under Section 59H. Her motion, however, neglects to address many allegedly defamatory statements which form a substantial basis of the plaintiff's defamation claim and which cannot be characterized as petitioning activity. For instance, the FAC alleges during Reed's first trial, she had a documentary filmmaker, Terry Moira, record the trial preparation, which included conducting recorded interviews with Reed over the course of the trial. During an April 30th, 2024 interview, Reed stated that Jen McCabe is a first-degree murderer and she knows it, that the plaintiffs know they killed. Copyright the plaintiff's father, John F., and the plaintiff's murderers. And they know it. FAC at Paris. 93-95. The FAC also alleges that during an interview on June 15, 2024, Reed told Moira and her team that Brian Higgins, Brian Albert, and Colin Albert had a motive to kill O'Keefe, and that during another interview on June 22, 2024, Reed told the filmmakers Tino Brian Higgins had a role in helping kill him, help him get in the snow and help frame me, but I don't think Higgins necessarily would have wanted to really hurt John. I think Brian Albert and Colin Albert would have enjoyed roughing John up. FAC at Para. 96-97. Although Reed did not...
They used that documentary filmmaker against her a lot.
Although Reed did not address her statements to Moira in her special motion, her reply brief argues that they fall under the 2nd, 3rd, and 4th clauses of GL circa 231, section 59H. However, she has failed to establish this is the case. As explained above, for statements to be reasonably likely to encourage consideration or review of an issue by a legislative, executive, or judicial body, they must be directed at an authority that could affect such consideration. The production staff of a documentary film is not such an authority.
That's not, first of all, that's not right. Second of all, he's basically rehashing his reasoning, so Aidan and Karen are going to have the same grounds for appeal.
There is also no plausible argument that the statements Reed made to Moira and her team were reasonably likely to enlist public participation in an effort to effect such consideration. The statements were all made in the midst of Reed's first criminal trial, and in the case of the June 22, 2024 statements, 3 days before the jury began deliberating. Because they were part of a documentary film about the trial, Reed could not have reasonably believed that such statements would be released to the wider public until after the verdict. Reed has also not established that the statements were made in connection with an issue under consideration or review by a legislative, executive, or judicial body. She argues only that the statements fall under this clause because the judicial proceedings were ongoing and she 12. Intended to publicize that she had been framed in order to pressure the Commonwealth to drop her prosecution and instead prosecute the true perpetrators. Reed reply at 3. However, the fact that she was involved in governmental proceedings does not make every tangential statement petitioning activity. See Global Naps, Inc., and the profit motive behind her speech is irrelevant to the threshold inquiry. She has failed to point to any objective indicia demonstrating that her statements to Moira were made to influence, inform, or at the very least, reach government bodies, either directly or indirectly. B. Aiding and abetting claims. The plaintiffs assert claims against Reed for aiding and abetting Kearney's defamation and infliction of emotional distress. Reed contends that her conduct was petitioning activity because it was made in connection with an issue under consideration or review by a legislative, executive, or judicial body, and reasonably likely to enlist public participation in an effort to affect such consideration. She, again, fails to establish the claims had no substantial basis other than petitioning activity. Reed's motion focuses on allegations in the fact that she communicated to Kearney non-public information that was in court filings or that was evidence in her criminal trial. she does not explain how her providing Kearney, as opposed to the court, with a police report with the plaintiff's private addresses, phone numbers, and social security numbers on it was petitioning activity.
Federal
CGL
government.
Circa 231, Section 59H. Petitioning activity includes any written statement made before or submitted to a judicial body, emphasis added. 13. Even if such communication could be considered petitioning activity, the aiding and abetting claims extend beyond these select allegations. See FAC at Paris. 168, 191, 207. 4. Instance, the FAC alleges that Reed found and enlisted Kearney, an aspiring internet personality with limited reach in the
Aspiring?
greater Boston area, with no
Limited
journalistic
reach?
training, editorial standards, or oversight, who was seeking attention and money, and routinely engaged in provocation and courted controversy, to publish her false statements. FAC at Para. 18. She then told him that the plaintiffs were responsible for O'Keefe's death, and he broadcast such statements on his blog. See FAC at Paris. 33 and 37. Reed's motion does not address how such statements have a plausible nexus to her prosecution. Indeed, the fact that Reed chose Kearney as an outlet for her statements, knowing he would convey the information in a way that would provoke and inflame his audience against the plaintiffs, suggests that the statements were not meant to influence, inform, or bring about governmental consideration of the issue. Statements to the Boston Globe, a newspaper widely circulated in Boston and throughout the Commonwealth, were likely to reach the decision-makers at Department of Mental Health
Whoa!
and members of the public wishing to weigh in on licensing decision.
He's trying to say that independent journalists don't count?
Nor does Reed explain how the content of her statements to Kearney, accusations that the plaintiffs murdered O'Keefe, either directly or indirectly, called on members of the public to appeal to the government on her behalf. Statements with no potential or intent to redress a grievance, or directly or indirectly to influence, inform, or bring about governmental consideration of the issue, lack a crucial characteristic of petitioning activity. See other claims. The remaining claims against Reed alleging intentional and negligent infliction of emotional distress and civil conspiracy all have a substantial basis other than petitioning activity. The claims allege that Reed orchestrated a campaign of harassment against the plaintiffs which included funneling information to Kearney and hiring a private investigator to confront the plaintiffs, that she and Kearney agreed on a scheme to defame, harass, abuse, and intimidate the plaintiffs, that she provided Kearney with non-public and confidential information about the plaintiffs, and that she celebrated the destruction of the plaintiffs' reputations while monetizing the publicity. Reed's motion does not attempt to explain how any of this conduct could be considered petitioning activity. Rather, she argues that all the claims are based on Reed's alleged defamatory statements to Kearney, which she contends were all petitioning activity. 4. Reasons stated above, the court concludes they also are not. Because Reed has failed to show that her statements and conduct at issue in the plaintiff's claims were in an effort to petition to the government for redress of harm, she has not carried her threshold burden for an anti-SLAPP motion. The court therefore need not proceed to the second step of the analysis, and the challenged claims will survive. 15. Order. For the foregoing reasons, defendant Aidan Kearney's special motion to dismiss plaintiff's first amended complaint pursuant to the anti-SLAPP law, GLC, Section 59H is denied. Defendant Karen Reed's special motion to dismiss pursuant to the anti-SLAPP law, GLC, Section 59H is also denied.
Alright, so that's the end. Okay? It's not the end of the motion to dismiss analysis, but I have to go to the doctor. My name is Grant Smith Ellis. Thank you for watching Towel News. I don't even have to do the analysis again because he mailed it in and just stated the same grounds. He didn't even do the second analysis. Nonsense. Sorry, not buying it. It's ripe for appeal. And then, because he didn't reach the second step, if any of his analysis is wrong, the appellate court is going to de novo from the original record, which is the only type of motion, anti-SLAPP, that you can get de novo review on in a civil trial. They're going to review the record, and if they find that he didn't do the first prong analysis right, then there's burden shifting, and there's a whole nother analysis to this. This is going up on appeal. My name's Grant Smith Ellis. I got to go to the doctor. I'm going to get a call and get yelled at. You can donate. Cash App, $, Grant Smith Ellis, if you want to buy a towel dinner. Venmo, at Grant-E1. PayPal.me/Grant Ellis. Thank you for watching Towel News, YouTube.com/@Grant Smith Ellis for more. I didn't even have to do the analysis twice. It was that. Did you see that? It was that lazy of a motion of a ruling in the second part compared to an appellate court ruling. I hope you found today's content interesting. Thanks to almost 10,000 of you who watched. Thank you for supporting Tal News. Shout out to the cupcakes. If there are war updates, you know I will be there for them. This was a motion analysis or ruling analysis. Obviously, you went around the globe with me on it. I hope you had fun. God bless you all. Thank you for supporting Tal News. I appreciate and love every one of you. Try to do some good today. And hold on, my friend Francine is here. Oh, I dropped my keyboard. Francine, Pete wanted to say he loves you very much. He'll see you later if there's war news. Otherwise, he adores you. Thank you all for supporting Tal News. I gotta go. I'll be back soon. We have another motion to dismiss ruling coming. We also have FOIAs coming. Kyle, as soon as the FOIAs come out, make sure you let me know. Tag me. I gotta go. My name's Grant Smith Ellis. Thank you for watching. I'll be back. You're all wonderful.